Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And with me today is Uncivil Law. How are you doing, man?
I'm doing great. I'm really happy to be here, and I'm glad we finally got this scheduled. It's been a little bit.
Yeah, it's been a while. It was the first time you commented on the case, I got a bunch of like furious messages of people saying,
Yeah, I bet you did.
There's some guy like trashing Vic's case. I'm like, what the hell is this? So I go and I check, and then you're giving like a pretty straightforward take. I didn't notice anything, like crazy. And so I'm like, oh, well, cool. I think I jumped in the comments, or I don't know if it was a live stream or if it was the comment section, but I was like, hey, I think we'd get along pretty well.
Yeah, I think we get along pretty well too. Like everything I've ever heard you say about the case seems pretty on the level. You know, sometimes we disagree on the conclusions a little bit, but the analysis is basically right. So I'm like, yeah, it seems like we get along pretty well.
Oh, well, thank you. That's you always wonder when it's like, oh, okay. Yeah, well, I think we get along pretty well. You're a giant idiot, but that's okay because I like idiots.
That's possible too, yes.
Well, guilty is charged anyway. You mentioned right before we started that you have whiskey at the ready.
Yes.
What are you drinking?
Well, with ginger ale today, I am mixing in classic Buffalo Trace.
Very
classic,
nice.
Solid choice. What's not to love with a little classic ginger ale. So cheers to the chat.
Oh, yeah. I've never had whiskey mixed with ginger ale. Sounds good.
Recommended.
Okay. I drink almost all my whiskey just neat room temperature because I have enjoyed the pain of that. And
sure, I do that sometimes too. But today felt like a ginger kind of day.
Perfect. I am drinking Eagle Rare, so cheers.
Ah, yes. Which is made by the same people.
Yeah, I got my local, I live in a tiny town, like 1,500 people population. And the little liquor store here, the guy likes bourbon.
Mm-hmm.
So he has like a liquor store with a bunch of crappy alcohol. And then he has a pretty good bourbon section for this little liquor store next to a tiny grocery store. It's great. So he had a bottle of this Eagle Rare, and he's like, oh, yeah, these things fly off the shelves. Okay.
It's a great one. It's a classic. I've had it many times. Love it.
Yeah. So, well, let's start off with a couple things. Of course, you are a online commentator as well, so we have a chat going. I believe I sent you the link to the chat.
You did.
And so if you want to follow along with that, you can. And that is always a judgment call. Because it's distracting. So I
from my experience, your chat is a little bit more rowdy than mine.
They get riled up, but it's okay. It's okay. At the end of the day, I firmly believe this is the best chat on YouTube. So, but anyway, we do have super chats and stuff that we'll get to as we go. If there's anything you particularly don't want to answer, you don't have to. Like if it's a personal thing, obviously. But anything you do want to answer, feel free to jump in. But we'll get to those in a minute. First, I want to get to know you and introduce you to my audience who may not be familiar with your work, and just kind of give us a rundown of who you are and why you're on YouTube and doing this stuff.
All right, so I'll give you my brief CV, I guess.
Yeah.
I graduated from Clemson University with a BS in computer science and a BS in political science in 2004. Then I went to University of Akron Law School in Ohio. Then I went to Virginia, took the Virginia bar, and have been operating on my patent law license. I took the patent bar when I was a 1L because you don't have to be a lawyer to take the patent bar. You can do it with just a technical degree. So I've been working as a patent lawyer for the last 12, 13 years.
Nice.
And one of the reasons, there's a couple reasons I do it. One of the reasons is I feel like I understand my own field very well at this point. And so the intellectual challenge is not there as much as it used to be.
Right.
And one of the reasons I started doing this is I I love reading cases from all these disparate fields. It feels like being in law school again, and I liked it the first time. I like reading all these cases from these different areas, and then I try to ask myself questions like, how do these principles or how do these cases in contracts relate to this thing from tort, relate to this thing from civil procedure, relate to this thing from constitutional law, relate to this thing from bankruptcy, and how can I start like making connections between these different fields?
Sure.
So it was partly out of intellectual, feeding the intellectual stuff. I like that. I like the abstraction of it and just wanting to learn more. And I do always enjoy the academic side more than the practice of the law too. So it's like, well, I heard a great comment from Jason Alexander, who played George on
Right.
Seinfeld. And he said that with relation to acting, he said the days of waiting for someone to give you the gig are probably over. You must make the gig. You know, you must put together the things. And if you do that, a couple things will happen. One, you'll be happy. Two, you might make a living. And three, someone might see it and give you an opportunity you couldn't generate yourself.
Right.
So I was like, well, if I want to be a teacher in law, why not just hire myself? Because that's an option now.
Yeah.
So I go onto YouTube and I'm like, okay, I'm a professor now because I've hired myself. And I have, 15, 16,000 subscribers now, which I've gained in the last year, which I think is pretty good progress.
Very good.
I'm regularly getting 1,000+ people watching my videos. I'm like, that's more than I ever get in any law school class.
Right.
So as far as I'm concerned, things are going pretty well.
Yeah, and having 1,000 real people watch is way better than 30 assholes.
Yeah.
that's how I picture law students generally. There's some good ones out there, but on balance, they're the same type of person that I was, right? And I remember me, and it's like, oh God.
Yeah.
So no, that's awesome. I have a mildly different origin story, but similar sort of themes. You didn't ask, but I'll expound on it a bit. I was a fan of a podcast. The podcast was two co-hosts. They had a bad breakup, and it's the biggest problem in the universe was the podcast. And if I could give you a recommendation for something fun to do, it's to check out this lawsuit. Now I've done a 40-something videos on it. We followed it from start to finish. It was an absolute disaster. And it was one of the funniest things still to this day to me to read. It was also the source of my first ethics complaint. So it was lots of progress was made. But
you're not talking about non-sec, are you? Non-sec show?
No.
Okay.
No. The show is called The Biggest Problem in the Universe.
I'm sorry.
No, that's okay. And it was it's two old internet satirists, Maddox and Dick Masterson. And they had a great podcast. Biggest Problem was a fantastic show. They had about 110 episodes. I think it was 107. Whatever. And they just suddenly it stops, right? Dick is not on the last show. Whole thing stops, and then they go and start their own separate shows. And after a little while, Dick starts telling this kind of the story of the breakup a bit, and then suddenly he gets hit with a lawsuit from Maddox for somewhere between $20 and $400 million. It's written
seems like a lot.
It's a little bit much, I think, and it's written in such a way that you can't tell how much they're actually asking for, because there's like 13 causes of action, and each one has an amount, and lots of them are this 20 million amount. And so it's like, okay, maybe those are combining, but it doesn't indicate that. And then some of them are like 1 million and 5 million. It's like, okay, but these are different. So is it aggregating all of them? What is going on here? And yeah, so the lawsuit is there. It's written, and I thought one of the guys wrote it and just hired an attorney to file it. I thought Maddox wrote it himself and hired an attorney to file it for like $500 or something. But then as the case progresses, you realize, no, this guy actually wrote the document, this lawyer. And it's embarrassing to read. It's a travesty, but I won't spoil it beyond that. It's a great one. If you want, I can send you links to the filings it's in the New York system, so you can just grab them for free off their website.
Okay.
But if you like reading case law, there's a really bad attorney in there, and I think the guy's actually kind of a travesty to the profession, because on multiple occasions, and he even did that in this lawsuit, he gets his clients to the point of being in trouble with bad evidence, bad faith evidence submissions and stuff like that, and then he bails, and then he sues them for money, for the fees.
That's super promising.
Yeah. Yeah. So anyway, I'll send you some stuff about it if you want to read it sometime. It's delightful. It's delightful. So
sounds like Leibowitz, which Leonard French covers. This guy Leibowitz, who files a lot of these copyright troll suits, and it sounds like
sure.
Leibowitz, who just gets in trouble all the time because he's overextended and filing all this really dubious stuff, man. So there are a couple people out there who make the rest of the profession look bad, I guess.
Yeah, I try to be one of them. But but yeah, so they have this lawsuit, and I'm just sitting there on my couch with my wife, and we're watching TV, and I get like bloop, I go on Twitter, and the complaint is posted by one of the parties, and I start reading it, and I was like, oh dear God. So I start drinking whiskey and just reading this thing on a camera, and I'm like, I'm gonna just tell people like what's going on, because people are freaking out. They're like, he's being sued for $20 million. The show's over, everything's a mess.
Yeah.
And I'm like, no, don't worry about it. This one's gonna be okay. So that's how I got my start, and since then it's been kind of crazy. But the thing I liked about it is exactly what you were talking about. You get to engage like these areas of law and jurisdictions that you would never have an opportunity to engage in. And you get to kind of look at the choices people make, the things that they write down, decide if you would have done that or not. And just kind of see how, and then you get to see how it goes without worrying about like, oh, my opinion cost someone, their livelihood or whatever. It's my opinions were tested against reality, right. And that's the end result. And we all get to learn from it. So it's great. But,
and hopefully a little bit more dispassionate too than any more in the role of the judge, where I could just look at this dispassionately. It's like, I don't care who you are. I don't care who any of these people are. I just want to know what the law is.
Right.
Just let's figure out what the law is and apply it, and whatever happens, happens. That's kind of where I start from.
Sure. I come from a different place of meanness most of the time, but I kind of like to get in there and tell a story with it sometimes, if it's appropriate, or sometimes I have my like opinion of how things might be going, and then it gets undone completely. One of the subjects I think we'll get to later is Rittenhouse, for example.
Mm-hmm. Yes.
And so when I watch those videos, I'm like, okay, they're going to charge this guy because he shot 3 people on camera. 2 of them died. It's pretty hard to not charge a guy in that situation. Then, and what I expected was a complaint from the prosecutor that basically laid that out, that he did this stuff. And then what the prosecutor wrote down blew my mind. So I'm like, why in the hell did you write this? This just says this kid looks like he was defending himself. Like, you're saying that. And so that's confusing to me. So that's one of those where, I had my conception of how it would work out. I talked about it on stream, and then they went ahead and do it. And then the next day I'm reading the complaint and like taking back everything I said. I was like, nope, this is way different than I thought it was going to go. But
yeah, and at least for me, like, I still feel like I really have no idea what I'm doing in this YouTube game. Like, I've only really been doing this for a year, a little bit less than that. Yeah. And I feel like it's going okay. I started just reading opinions in full, and that didn't work. And still some of the content I produce is fairly lengthy, because I still read huge excerpts, because it's more in the mode of trying to actually teach and read this and try to explain it. Take time. Is that the most effective way to do it, or the way to get the biggest base possible? Probably not. Is there a better way to do it? Probably. Is that the way Eagle does it? Probably not.
Don't be that guy.
There's probably some better way than the way I'm doing it. So I know you've been in this game longer, so maybe you can teach me how to avoid the pitfalls and get me to where I need to be faster.
I don't know. I honestly don't. What I try and do, the hardest part is finding content that's consistently interesting from a non-lawyer's perspective as well as a lawyer's perspective. Because I was going to ask you like how you fish for content, because that's a hard thing to do. Is like, okay, I got to find a case that I'm interested enough in, that I can get enough information about, that I can comment on, that isn't written like a drywall technician watching the drywall dry, right? It's you have to find something that's got some entertainment value. Like there was one case I read that I thought was going to be funny because it was cited in a different case, and it was the site included the line hookers and blow. I was like, this case is going to be great. And then I go read it, and it's milquetoast, except for that one tiny paragraph, which was mildly funny. It's like, okay, well, that kind of flopped.
Well, I tend to read opinions rather than lawsuits, although sometimes I'm obviously doing that because I've covered the Vic case, which doesn't have a final opinion yet. But most of the time I'm covering courts of appeal or state Supreme Court and a lot of U.S. Supreme Court cases. So I cover quite a lot of U.S. Supreme Court cases. When they're in session, I usually do at least one of their cases from the prior week and do an oral discussion. This week I did Google versus Oracle, which is a copyright issue, which I think is endlessly fascinating in terms of the implications of computer code and when it's copyrightable and not, and implications. I do a lot of 1983 cases for when the police are shooting people or when the police are abusing people, which are always entertaining because, you get these horror shows of here's the time the police went up to the tethered dog who was all the way at the end of his lead, already at the end of his lead. And the police then walked up to him and shot him in the head for no reason. Does the police get off of this or not? Let's discuss this horror show,
Yeah, they killed the dangerous Yorkie.
Yeah, the dangerous Yorkie who was on a tether, who could go no farther. Yeah, that kind of thing. And so sometimes people bring things to my attention, and it's kind of what I find interesting. And I think people find it interesting because I find it interesting. I tend to inject, my own enjoyment into it. So hopefully most of the time it's not super dry.
Yeah, no, and that's the key that I've found. And that's actually the biggest challenge when I'm looking for stuff is, because like a friend of mine, that umbrella guy, he covered the Johnny Depp versus Amber Heard suit, and he's like, man, you got to cover this, people love to watch it. And I was like, I know they do, but I just don't care about celebrity divorce. Like I should, like, it'd be in my financial interest to do so, but I just can't bring myself to read like that horror show and go, you know what?
I never took family law in law school, and I have no interest in it. It just feels like a world of pain. I'll leave that to someone else.
Yeah, it's awful. It's awful. Well, I guess that's a good use of getting to know each other a bit and getting introduced. So what I want to do is I want to read some chats and catch up on the ones that are in here. And then let's jump in and let's start talking a little bit about the Vic case, which is how, of course, I got exposed to you, and probably how several of my viewers did as well.
Sure.
And we'll talk about that. And we can talk about the fallout that recently occurred. Your reputation will rest in peace. But we'll do that in a minute as well. Okay. First one, It's a Jackal sent a huge chat. Just a huge chat. Thank you so much. He says, the other shoe just dropped regarding Rooster Teeth. 2 employees leaving due to allegations, kind of like what happened to Vic. Just thought you should know if you didn't already. P.S. Longtime fan. Keep up the great work. Hey, thanks, It's a Jackal. I've seen it. I've seen the Rooster Teeth stuff. I want to put together something on it, but then, they left. And then Rooster Teeth put out a statement yesterday or today, something like that. So I've been kind of holding off and seeing what's coming. I feel like Rooster Teeth is maybe under attack, which you won't catch me crying about it. But that's a funny situation for Rooster Teeth. It's a sad situation for the wives of the 2 guys involved. And I don't. I don't take any joy in that aspect of it. That part of it makes me actually really, really angry. But yeah. But thanks for stopping in. Thanks for supporting the show. Ryan Mercado says, hello, Nikki and Uncivil Law. How are you both doing today? I'm pretty good. Yep. He says, Uncivil Law, what's your honest opinion on Ty Beard?
Well, I can't speak to him globally, but with respect to his filings in the Vic case, I found they left something to be desired.
Hmm. That's a common assessment from people who I've seen look at it. The way I look at it is, the lawyer in the case is going to make tactical decisions. They're going to choose how to approach the case, and sometimes people are going to agree, and sometimes people are going to disagree with how that's done. But yeah, no one's asked my opinion. That's rude.
Well, you know him better, that's for sure. What do you think?
I think Ty's a great guy. I think he's a great attorney. There are clearly things that I would have done differently, but again, it's really easy for me to say that because I'm not I'm not the guy who's who's putting his bar number on the paperwork.
Well, to that I would say yes and no. I mean, on the one hand, we are Monday morning quarterbacking, but on the other hand, so are the judges.
Right.
So are the courts of appeal. They're Monday morning quarterbacking too. It's like, well, I don't know why you made the decisions you did, but we did, and now we're the refs, and we have to call this play.
Mm-hmm.
So I'm in no different position, except maybe a lack of understanding of the law, because presumably a Texas Court of Appeal judge knows it better than I do. But other than that, it's like we're both Monday morning quarterbacking, right? We're just trying to figure out what we think based on what you did. It's like, well, here's what you did it work or not?
Right. And that's and we'll ultimately see. One thing I can definitely say about Ty with regards to this case specifically is I think Ty did a very good job of stopping some of the stuff coming in against Vic, or at least blunting how it occurred. I think that he stood by him the entire time. And I think that he, along with the support of the fans, lots of people who watch this show especially, have made it so that whatever the outcome, Vic has some sort of future. It may not be in anime voice acting, but it may be in... I think he's working on another audiobook right now, which is great for him. It may be in something else entirely. He does music. He has... and he's been going to quite a few conventions this year, even though many are canceled. So... what at the end of the day, this is one thing I maybe want to talk to you about too, is one thing that I notice a lot of analyses of these sort of situations has a tendency to leave out is there are other aspects of the case and whether you win or lose in court. And sometimes, you always want to win. That's the goal. That should be the goal of every lawsuit. But sometimes there are ancillary effects that are good, even if the outcome of the case isn't the desired outcome. So I kind of wanted to get your opinion on that. And I was going to talk about it a little later, but maybe we could talk about it briefly now. What do you think about that? And let's take it out of the Vic case because of the drama involved with it. And let's contextualize it in something else. You've got Lin Wood representing Nick Sandmann, for example. And you've got him representing Kyle Rittenhouse, which is a little, but but whatever the case with Sandmann, we don't know what they settled for. My assumption was the first settlement was likely for almost no money at all. The second settlement was probably somewhere close to that as well. But now he's got 4 companies lined up. They've just passed their motion to dismiss, and they're going to go into full-on discovery mode. And that's where cases like this against major corporations get really interesting. So what do you think about the internet's ability? And I specifically couch it in the internet because it makes money and support available to people who didn't have it 15 years ago. What do you think about the internet's ability to make populist lawsuits important? Does that make sense?
I think that's fine. I think even making it one step broader than that, I think people have a right to advocate for things that they want, and I mean, join special interest groups that advocate for things. So if you're a member of, insert your nonprofit organization of choice here, one of the things they might do is file lawsuits to help further that interest. And that's a classic thing for people to do. So I think it's probably good for people to find causes that they support and try to support those causes and try to advance something. I think that's perfectly fine. I think a lawyer's job as counselor can extend beyond law. And so you can look obviously to interests beyond the outcome in a case, because there might be lots of potential different outcomes. And sometimes you're not really suing for what you're suing for.
Sure.
Sometimes something else is really going on.
Are you talking about Derek Chauvin's tax implications, for example?
Yeah. Sometimes there are other things going on. So maybe you're filing suit for one thing, but you can help achieve what your client's real objective is. Maybe your client is, suing their former business partner because of this, but they're really upset because of whatever. So they have the legal hook to get their redress, but that's not really why they're upset. And maybe you can get them what they're really after in the end. I think that it's okay to look for things like public reputation improvement. It's okay to look for things like publicity. It's okay to look for all those things. My only sort of counter to all that is I think, a lawyer has a duty to bring cases that are non-frivolous. Right. They have a duty to bring. So I take strong exception, deep exception to lawyers who are filing cases that are unmeritorious because they're looking to achieve other things. That's a bad. You're abusing you're abusing the legal system. You're not supposed to do that. If you can further the goals of the legal system and also at the same time accomplish a whole bunch of other stuff, I'm all on board.
Right.
But if you're using the legal system as a vehicle when you really don't have a legal case, I hate you. Please stop.
Yes, please, because it slows everything down too. Yeah. Like that stuff clogs up the courts. One of my favorite litigants, although I wish he would stop, is a guy named Russell Greer. And he sued Taylor Swift. He's on his 4th time suing Taylor Swift now. And it's like, Russell, your argument is still the same as the last 3 times, and it wasn't good then. Just stop. His argument is basically that because she posted a couple nice things people did for her to Instagram, that since he wrote a song for her, she's obligated to either listen to it and share it with the world, or she's obligated to to issue a disclaimer with every single good thing that she posts, that she's not going to post every single thing. Like, he wants all celebrities to have a mandatory disclaimer that they may not address him, or in the alternative, one dinner date with Taylor Swift. That's the other option.
Definitely not.
Yeah.
Definitely not.
Okay, Bad Vibe says they say the early bird gets the worm. I say someone with a fat bird as a Twitter profile picture needs to sleep in for at least 2 weeks. Oh my goodness. Mike Walters says, did you have a chance to read email I sent about interviewing you and Ty about comics on my channel? I did read it, Mike. I owe you a reply, but I did read it. Yes.
He's super prompt about the reply, so don't worry about it.
I think didn't you email me like a year ago? Somewhere close. Oh God. Sent email 2 weeks ago. Oh, you got like 6 months to go. Forward it last Friday per your suggestion. If you hadn't, could you look at it if I forward it again? No need to forward it again. I have seen it. I have read it. I will reply to you. Bad Vibe says, Flycoon abandoned you for Pence. Yeah, no kidding. Flycoon is now more popular than you. Clout chasers, take note. Nick might be master grifter, but Flycoon is master clout chaser. Did you watch that VP debate?
I did. It was a lot better than the presidential debate. I'll give you that for sure.
It was. But I mean, the fly landing on Pence's head and staying there for like 3 straight minutes was amazing. Because I haven't seen a fly sit that still ever. And I almost thought maybe he got caught in Pence's hair gel. But no. Do you know anything about Pence as a lawyer?
Not really, no.
Okay. It didn't occur to me. I forgot he existed, in all honesty. He's been, Trump is such a like front and center guy on all this stuff that Pence kind of melded into the background. It's like, I was reminded when he led the COVID task force and then I forgot again. And then, so it's like VP debate. It's like, oh yeah, Mike Pence is VP. I wonder what this is going to be like. And he came out and I thought his performance was pretty good during the debate. And I was like, this guy seems like a pretty nasty litigator. And so I was curious if you knew anything about his actual practice at all,
No.
but I didn't. Sakaki Onsai says, good evening, Nick. Mr. Uncivil Law. Welcome to the chaos. I see you on Viva's streams at times. Just a comment. I'm very sorry that you have had to deal with Law Twitter. You should never apologize to them. Be you.
Yeah, that has been the sort of the cherry on this parfait over here. For a long time, the Vic fans have been super critical of me for saying mean things about Vic, because that's been my analysis. And then I go and say, well, this brief by you is actually pretty good. And then Law Twitter gets upset at me. So both sides hate me because I've said nice and mean things about the other side. So yay.
I never got the impression that you said anything overly mean or unfairly critical on Vic's side from what I saw. Now, full disclosure, I didn't watch every video on it because I don't watch much of anything. As you probably are aware, like, doing this takes a bunch of time.
Yes, it takes a lot of time.
And so I don't watch a ton of stuff. But when I saw your stuff, the one thing that I had it wasn't even a criticism. It was, well, there's a bunch of facts here that he's not aware of, but then that's also maybe an indictment of some of the pleadings, right? And it's like, if he doesn't know them, maybe those things should have been put in. Maybe that's something that, like, when in my analysis, since I'm been deep into this thing the whole time, maybe I'm overlooking stuff and assuming knowledge where I shouldn't. And that was one of the interesting things that I saw in some of your analysis and it was like, oh, well, that isn't good. If he doesn't know this, maybe it wasn't presented well, but that was it. I never saw you be unfair or anything. So,
I mean, that's all I really try for is try to be fair and try to give the most even analysis I can, as such as I'm able to.
Right.
Just try to call it like I see it, and it's like, well, it's like, yeah, I read, I started with this blind. I didn't know anything at the start about Vic, including how to pronounce his name, as people who watch my earlier videos are well aware.
Right.
So I didn't know anything about this or what was going on. And so I just start with the original complaint and the response and the TCPA response, TCPA hearing, and all that stuff, and just try to, and I'm just basing it based on the filings. I'm just looking at it. I'm like, okay, well, this is, and then people are like, well, you didn't know about this, this, and this. I'm like, well, I don't know if that's my problem. Yeah.
Yeah. The one thing, the most surprising thing to me about the case, though, was I was at the hearing, the TCPA hearing, and I get a different impression reading it than when I was there. I was dumbstruck the entire time. I was like, I'm not a litigator who's done 100 million cases or anything, but this doesn't feel like this is going right. I knew it wasn't going well, but it didn't feel like it was going right. And I was like, God, this can't be how TCPA hearings go. And it felt very, very awkward. And so that I think is one of those things where when you get, you take a case to court and you're rolling dice in some ways, and they got Judge Chupp, and I have looked, and I don't think he's ever done a TCPA hearing before that. And I know this may displease the people who are watching this, but at least based on the cold record, because I wasn't there, just based on the transcripts, which I did cover. I read them and I gave analysis of the transcript, but based on the cold transcript and based on the cold analysis, it looked okay to me. Now, maybe there was a different feeling in the room, but just based on what I saw, it looked okay. Looked right. Yeah. And
one man's opinion.
Yeah, absolutely. And you shouldn't, no one in chat should excoriate you for any opinions that you have, in my humble opinion. I mean, I'm not in control of the chat, or maybe I am. I'm running 1,900 bots right now, chatting, but no, it's a fair analysis. It was so, when I was there in the courtroom, I was like, this is baffling to me on some of the things that were going on, but that's not, we're going to talk about the case in a little bit, I guess. Caitlin Roberts says, hi, Nick, just wanted to say I loved your show last week with Anna. I'm a 25-year-old virgin who hasn't dated much, and I related to her a lot. I've been following since the Vic case. Love your show. First time super chat. Thank you for that. Thank you for that. Catlin, Catlin or Caitlin, it looks like Catlin. Thank you. Thank you for that. And yeah, if you ever want to chat about any of that stuff, feel free to email me. If you want to come on the horrific gauntlet that is a chat with Drexel, feel free to shoot me a message. Mithrin Emrys says, can confirm 80% of law students are assholes. The other 20% are condescending assholes. Mega says, hey, Nick and Uncivil Law. Today was my grandmother's 82nd birthday. We had barbecue. I ate 3 steaks and a sausage, probably the biggest meal I've ever had. My question is, what's the biggest meal you two have ever had that you can remember?
Probably a Brazilian steakhouse. Yeah,
Yes.
some Brazilian steakhouses are great.
I love them.
Yeah.
I get 2 things of broccoli and then nothing else but meat the rest of the time.
Excellent. I love it.
Then I go cry. My biggest meal was, it was actually with my friend Drexel. Have you ever been to a Buca de Beppo?
Yes. Yeah, I really liked it when I first went there. The one in DC where I used to live wasn't as good, but the one in Ohio was pretty good. And
Sure.
in Cincinnati, was it? Yeah, but yeah, Buca de Beppo is really good. They give you huge portions.
They used to have a dish called it was chicken cacciatore, and its subtitle was 7 pounds of love. And Drexel and I sat down and ate that together.
Excellent.
And we ordered it, and the waiter laughed at us. And he's like, "You're joking." So it's like, "Oh, you don't know who you're dealing with." And then we sat and ate the whole thing. And then we went and got in my car. My car was a 95 Ford Escort. And
Nice.
I just reclined the seat and fell asleep in the parking lot. It was horrifying. But it was good. It was good. Is it actually 7 pounds? Yeah, it was like 2 chickens on top of a plate of mashed potatoes. It was disgusting. Every game played says other good lawsuits are Greer versus Swift and Greer versus Null. Yep, those are great. Those are great. Russell Greer. Like I said, he's one of my favorite litigants. Okay, let's talk about the Vic case a little bit. I don't know where to.
I think it's going
start.
very, very poorly for Team Vic. With all due respect to the chat, I think it's going very poorly, and he's going to get hosed by the Court of Appeals.
Yeah,
that's where I'm sitting.
And my analysis hasn't been worded that way, but it's been relatively similar. I've said anytime you're trying to overturn a decision on appeals is always it's an uphill battle, and you're fighting against the odds and you're fighting against the presumption. You've already failed at one level, so now you're trying to get a do-over and say we failed because a guy who's supposed to make these decisions made a mistake. That's a tough thing to do.
Right.
So I've been trying to let people know that Vic's chances on appeal are pretty low. I think your initial estimate of 10% was a little lower than mine, but I tried not to put percentages on it. But mine was certainly below 50% chance. I'm hopeful, of course, that they will overturn it. I do think that Vic has a meritorious case. And one thing that frustrates me about how the TCPA operates is ostensibly it's there to protect meritorious cases, but there are ways in which a meritorious case can not proceed because of the TCPA if there's some shortcomings on the filings or on the procedure that occurred leading up to it. So.
That's kind of where I sit. I sit. I mean, I wouldn't know for sure, but based on my sort of impression, my impression is that he had a theoretical meritorious case, but what was actually filed and actually argued, less so. And that I think is a point of frustration for the Vic fans that I totally understand. Mm-hmm. Like Vic's odds of winning in some sort of platonic universe where things were done properly are better than they are now, in my opinion. And I just feel like there were things that were not done that could have been done that would have dramatically improved his case, particularly on the tortious interference. And I feel like there were a lot of blown opportunities, and I got the impression he was trying to be too clever by half and got caught up in some things that he couldn't extricate himself from. And that's kind of the end of the ball game.
For me, I think one easy to understand and identify example that everybody's familiar with is the affidavits themselves being
Yeah.
notarized over the phone, which is not something that you can do. And that, of course, has been a point of contention, because if those affidavits were withdrawn, and then the unsworn declarations, though I think they should have been considered, they're not being considered. And if the appeals court agrees that those remain unconsidered, or even suggests they should be stricken for timeliness or whatever it is, if they agree with that, then that's an identifiable error that is like, yeah, that, I mean, that happens. And there's, as a practicing attorney, you can make all sorts of answers for why things were happening at the last minute, but at the end of the day, the judge and that doesn't matter. Like,
Right.
you either got it in or you didn't, and so we'll see how that goes. That's been that honestly is one of my most frustrating aspects of this case, because I do think that those affidavits, at least the one of Chris Latosh in regards to the entire TI with Kamehacon issue, is really important. And then I think Vic's affidavit is really important. I'm not a huge fan of Chuck's affidavit, but and I don't think it was super helpful anyway. But
Yeah, I have to wonder if it could have been possible to get any sort of statement in writing, ideally, from any of the other conventions that canceled on him or refused to renew with him, because he presumably knows, or could find out easily, what conventions he's been to over the years. And he could say, well, here's the conventions I've been historically invited to and re-invited to, and here is the reasonable expectations I would have had. And that didn't happen. So isn't there some way, if I was trying to do this in the first instance, as if I were hired, isn't there some way for me to try to contact these people, either directly or through an intermediary, such as a private investigator? Is there some way for me to contact these people and get some sort of statement in writing, ideally, about why they did what they did? An email would be fine, because then it gives me enough basis to then, like, say, well, I have this statement and I can obviously perfect it in a deposition or affidavit or whatever, but at least I have something. And the other thing that was a blown opportunity was for the Discord, because my understanding was there was a Discord from the Vic haters, and that would have really helped, presumably, because things were being said that would have gone to show a common pattern, a common scheme, conspiracy, that perhaps the specific actions they took. Well, I'm going to call so-and-so. I'm going to email so-and-so. It's like, oh, okay, great. If I have that, then I can say, hey, did you receive that call? Hey, did you receive that email? What was your response to that thing? And so forth and so on. And the thing that's frustrating is the plaintiff, Vic, is in control of when the lawsuit is filed. Right. So they have the choice of when to make that initial decision. So it felt like there was groundwork, because people talk about the TCPA Discovery Shield. But because of that, I would try to do as much as I can before I ever filed in the first place. Why worry about a Discovery Shield? You can't have a Discovery Shield if there's no lawsuit. So why not go out and see what I can get in advance and try to get as much as I can to show, oh, I really have stuff. It felt like there was an opportunity to get things from these people that was not sufficiently developed.
Without, I don't know the answers to most of these questions, because obviously not on the team, but I do know a little bit about how difficult it was to get information from Chris Latosh, the one that they ended up getting information from. The one thing I can confidently say about the convention industry is it is very insular and very cliquey, and that I think most of the people who would even talk to Vic kept him at the shows, and the rest of the people honestly were not talking to anybody about the situation. But that's the impression that I got early on. Now, if you wait 4 months to file, 6 months to file, maybe that sentiment fades and wears out. But then, of course, I don't know what conversations are going on between Vic and his team about, you know, the strategy of when they file and stuff like that either. So
Yeah, you know, I feel obviously Vic himself maybe wouldn't be able to get it from them, but you know, Vic has been in this game long enough that presumably he's got some friends who
mhm.
also go to these conventions, who also have relationships with some of the convention organizers, and could even make a discreet call/email about, hey, I heard Vic isn't coming this year. What's all that about? Oh, I heard that this, and this, you know, and then they could make like a, you know, I swear the following. I had this phone call and they
Right.
told me these things, you know, even like it's hearsay, but it's enough for me to be able to say, well, I have a basis to ask the question, because now it's like
Sure.
I have a basis to say, well, is this true? Because I heard this from this guy. And, you know, it's so there's like, it felt like there was opportunities to get things that weren't there. And the thing that was frustrating for me at the TCPA hearing in particular was it felt like Chop was giving Ty a couple opportunities to say what conventions did not give you. And if it's at least felt to me on the written record that Ty didn't know the answer to that question. He didn't seem to know what conventions Vic had been not invited to, he should have been invited to, or uninvited to, or whatever. He didn't seem to know that answer.
Yeah,
And
they
it felt
were
like Chop gave him a couple tries and he didn't know. And so I read frustration from the judge, and I was like, I understand why this is frustrating.
yeah, and this is part of that whole why it felt weird in the courtroom. One of the things they tried to do is they tried to give Chup their binder of evidence, which had they had everything laid out, you know, with page sections and everything like that. And Chup had taken one from the other party, and he said, "No, I don't want yours," and he wouldn't take their binder at all. Which I personally thought that was a little improper. I'm like, okay, so you're going to take a binder of evidence from the other party, but you're not going to take the binder of evidence from this party. And so then I know that you could see it while you're watching them try and answer his questions. They're looking through their own binder and trying to figure out how to communicate with him where those things were. But with respect to the conventions that canceled him, I think, and this probably in hindsight, I would say, maybe Ty would agree that he should have just pulled out the petition and started reading them. But all the conventions that canceled him with dates are listed in the petition. And it lays out in, I don't think it was in the original petition, but it was at least in the second amended, and I think the first amended petition, that once a convention has announced you, that you have an actual, at that point, you have a contract, either oral or signed, and that announcement is part of the performance of the contract. And that, so what I think,
presumably a estoppel, if nothing else, right? Because
right,
it's like you're relying on it.
Right. And what I think, yeah, because you're foregoing other appearances. It would
Right,
be the
exactly.
idea. So what I think happened, and again, I'm trying to get into Ty's brain in the hearing at the time, in the moment, and I'm also going to be biased because that's just where I'm going to be. Is I think he's thinking in the hearing, I wrote all these down. I wrote them all down in the petition. Why don't you know this? And maybe he's asking me for more, because that was the weird thing. And I noticed this in your video, at the end of your video on my brief, where you were talking about kind of this instance, and you know, they brought up Kamehacon because that's where they had all the evidence for the TI, and he's like, well, what other ones? And they're like, well, we don't know. And he's like, well, he went to Kamehacon, and they're like, but he had to hire his own security. He had to do these other things that he shouldn't have had to do.
Right.
And Chup just kind of went, whatever. And I think they were so dumbstruck by the idea that he would, whatever, what they thought were pretty obviously laid out damages, that it got kind of, that they got flustered with it.
I ideally would like to know what the idea behind the second amended being filed when it was why that decision was made that way. Because, you know, there's two possibilities. Like, it wasn't ready to file until that point, or it was ready to file and I was withholding it. And I feel like, you know, between that and the affidavits with the phone notarization and some other things, I feel like the judge had lost some trust and confidence in Ty, because he felt like it appeared to me, based on the record again, it appeared to me that the judge had reached the conclusion over various instances that Ty was playing games in a way that was improper. And so his affect as a result of that was very skeptical to anything he was doing. So when you say to me, for example, well, Ty's binder was refused during the hearing, to me that decision makes sense, because it makes sense because the judge was very skeptical of, like, what's in this binder? I don't trust you, because I've lost trust from these things where it feels like you're playing games. It feels like you're manipulating. It feels like it's unnecessary. And so I don't know why it wasn't in the original petition. It doesn't have to be, but why wasn't it in the original petition? Why wasn't it in the first amended? Why was it only in the second amended, and why was it filed so late? And putting aside the rules or the technical rules, you can't, like, at least in the abstract, you can't say, well, he was attempting to, even if he could, he was attempting to surprise them by putting this in the last minute, with all this stuff that they thought wasn't there. And, he's trying to do something that's a little bit dodgy, even if it's within the bounds of the rule. So it felt like the judge had just lost patience with Ty and lost respect for him.
Yeah.
And that's what I saw in the oral. So, like, I at least based on the cold record, based on what I saw, it felt like the judge was acting properly.
Sure. Yeah, and
out of that experience.
Yep, and that's something I hadn't really considered too much. I mean, I figured the judge was annoyed at the response to TCPA, which was not an ideal filing. It also had 1,000 pages of deposition transcripts attached to it, and that probably torqued him off a little bit. And then the second amended petition being filed late, and then one of the parts to the record to go to what you're saying is where Chup says, you're trying to get around this. Just say you're trying to get around this and you want it in. And I don't know. I felt like there was some communication mistakes that happened in that segment, because what Chup's like, just tell me you want it in. And so Ty's like, yes, I do. I do want this in. And he's like, well, whatever. We'll get to that. I think, and Ty talked about this, he was being deferential at first, and later he was a little more combative and maybe felt like he was doing better towards the end of the hearing. And it did feel like it was picking up a little bit. That's also where he started holding things for review rather than just dismissing them in court. But one thing that bothered me about that was I got the impression from Chup that he was annoyed that Ty was trying to get around something. And Ty was trying to communicate, I'm not trying to get around anything, because, and what he didn't say was, there's nothing to get around. These are two different documents. And that's the argument that he probably should have tried to assert. But what it came across as is, yeah, I mean, I'm not trying to get around it, but I am kind of trying to get around it. And I think that the second amended petition being filed when it was maybe a realization that the response to the TCPA that they had filed, a day or two before, was not what they wanted it to be. So in some ways, are they trying to overcome that and quote unquote go around it? Maybe they're trying to cure what they perceived as deficiencies. But the question is, can they? Of course, my opinion. My opinion is yes, because I wrote it down in the brief. But yeah, I can see why that would also piss off a judge.
One of the things I know for sure is, like, the unspoken rule number one is don't irritate the judge. Right. Unspoken rule number one is don't irritate the judge, don't anger the judge. Judges are in fact human beings, and they will respond as human beings, and they can only be so dispassionate at the end of the day.
Yeah.
And if you do something that causes you to lose respect, that's not good. And you have to be aware of that and what's going on. And it felt like, what was there a reason he had to file it when he did? Could he have filed it earlier? And so did he have it ready to go a week or 2 weeks or 3 weeks or 4 weeks before he did? and he was just holding it off on a tactical advantage.
Sure.
And it was just, one more thing on a list of things. And, you can, on some level, you can't, at least to me, maybe other people would, but on some level, it's like you can't blame the judge when it's like one more thing. It's like,
Yeah.
at some level, it's like, I just don't care anymore. It's like, it's like, I can't deal with this,
Yeah.
you're not really playing fair.
And that's, I did get the impression from the hearing that Chup was mad, although I didn't think his anger was specifically reserved for Vic's side. I think both sides had pissed him off with all of the filings to strike all of the evidence.
Sure.
Because there were, thousands of pages. Between all the parties filing all this stuff, and when you can see this in the record, specifically when Lemoyne's up talking on behalf of Rial and Toye, he starts he starts going through his thing, and Chup actually says, "I don't really care about this. Get to your argument." And the way he said it in court, he was not really pleased with them at that point, or maybe he was just frustrated with the situation. I don't know, but the first comment I made when we left the courtroom, I was walking with several viewers of the show, and we went to go find somewhere to sit down for a few minutes and talk about it before I had to get on the plane. And I said, "Man, he looked off. He looked off." And I'm not trying to implicate him in any way in this, but he looked like when you see someone who's had a couple drinks and they're flushed, or I've seen people who've been on certain drugs and have been they look agitated and out of it. That's how he looked. I don't think he was on a substance. I'm not trying to do that, but that's just the analog I can give. He looked off for the whole hearing, and I think, again, maybe he was pissed already, or maybe he woke up on the wrong side of the bed, but that's the roles you get sometimes.
That is the roles you sometimes get in this situation. And at least, again, on the cold record, it felt like Funimation's side was better able to answer the challenges.
Yeah.
So there were challenges to Funimation's side, but it felt like they were more on point in being able to respond to those challenges in a way that was, and it felt like Ty didn't know the answers or was flustered. It just felt that way on the cold record.
Yeah.
And so it didn't surprise to me that the conclusion the judge came to, and then trying to think about like what the Court of Appeals is trying to do. It's like, well, we're either in clear error or abuse of discretion analysis, depending on whether or not it's a factual or legal issue. And it's like, are we there? And I'm like, no. So it's like, I don't, it's what is true in some sort of ultimate reality. Did Vic actually get hosed is a whole nother set of questions.
Right.
But the law has a process for good or ill. And I think it's for good because it sets the rules and makes them clear and makes it clear what to expect. And it's hard for me to disagree with Funimation, not because I think that they're ultimately right in some sort of abstract truth sense necessarily, but based on the law, it just seems to be the correct conclusion.
Sure. That's fair. There's nothing else you can say about it. That's a fair analysis.
And it's not like I know everything or that I'm the end all be all. I'm not trying to claim that like I'm some sort of moral superior, Oracle of Delphi, like I'm telling you the one revealed truth. I'm not trying to claim that. I'm one man who has a very specific knowledge set in a particular field. TCPA is not that. I've learned most of it from reading this case. This case has been in education. So you could absolutely disagree with me, like you don't understand the law well enough, you don't understand this. It's like I can only base it based on the research I've done and the analysis I've done and the briefs I've read and trying to adjudicate it as best as I can. And maybe I'll be proven wrong at the end. If so, then I'll learn something. And that will be plus. I
hope so. Not so I can gloat. But so we can hang out and kind of learn what the appeals court has to say. Because I hope they have a well-constructed opinion for whatever decision they take. And I think there are some interesting issues that they can choose to take up. But one of the things you said in your video, which I think was very correct, is that they're like water, and they're going to find the depressions in a surface because
the Court of Appeals doesn't want to work any harder than they have to. They're going to find the easiest issue to resolve it on and resolve it on that. If they can say it's harmless error, which I called mootness, which Law Twitter had a massive problem with for some reason, because I call it mootness instead of harmless error. I don't know, but they had a massive hang up about that.
They must have thought he's misunderstanding the mootness doctrine. And it's like, okay, we can speak colloquially from time to time. It's okay.
It's okay. Yeah.
They've done that to me a million times. And
so if they can resolve it and say it's harmless error and it wouldn't matter either way, it's like they're not going to work any harder than they have to.
Right. And on the converse, I think that's why one of the reasons I picked the Rule 11 agreement and the Second Amendment petition is because I think that's an easy way where they can say, yeah, the Second Amendment petition should be considered. We'll just remand it and let them consider the Second Amendment petition as written, or they can they could do whatever they want. It's like, that's an easy way for them to go Vic's way as well. The other easy way to go Vic's way is something that Ty put in the brief. In one of them was, I believe this was fleshed out somewhere. It gets kind of jumbled in my head, but it was the idea that, well, we don't care about the Second Amendment petition. We don't care about the Rule 11 agreement because we've decided that there's enough stuff, that there is enough evidence in the record that just wasn't considered when you look at the briefs, the motion documents, and the filings that were there. The hurdle with that one is, I think, if part of Ty's argument, if I'm not mistaken, was that in their motion documents, they bring up all this stuff. And so if it's in their motion documents, they don't need the Second Amendment petition because it's there. But there's case law out there that suggests that motion documents are unsworn. So therefore, they're not evidence, whereas a pleading would be for the purposes of TCPA. So it kind of depends on if they want to take that approach, they're going to have that issue to deal with. But that was... It's interesting. I'm curious to see what avenue they'll take and where they'll go. Like I said, at the end of the day, I think Vic's in a pretty good spot to be a successful person, no matter the outcome of the case. But that remains to be seen.
And also, just like on a personal level, some of the things that he was accused of just feel like so like petty and banal. Like the whole thing with the jelly bean, I'm like, okay, I 100% believe that occurred, and I don't care. I just don't care.
Like,
I don't care.
Yeah.
He's like, oh, I ate Monica. I mean, it's a bit of a corny joke, but okay. And like, this is like the end of the world that he told this slightly corny joke.
That was my problem with it. It wasn't funny.
He might have one time, as he was passing through Funimation, he might have one time given someone a hug they didn't want and gone a little too close, and maybe because he was close, it felt like he sniffed his hair. Yeah. This is the end of the world. We're gonna live and die on this thing. Right. But apparently that's where we are. I was like, you cannot be serious, but apparently we're serious. Okay, that was good.
Yeah, that's and of course, I think that's one of the big victories of this case was publicizing that type of stuff.
This one time at a convention 10 years ago, he ate a jelly bean with my name on it. The horror.
I have vor trauma in my past, and so the idea of him consuming me was very, very traumatizing. It reignited. No, it's that one was crazy. And this is, of course, one of the questions, because that's Monica, and her big accusation, of course, came after the investigation, after he was fired, on Twitter, when she tells the story of the alleged assault in the hotel room 10 years ago. And I have all kinds of problems with the story itself, but one of my first things was, okay, wait, what? You reported him to HR for these various offenses, which were also years ago, and you didn't include An alleged assault? Like, you went with the jelly bean. You talked about the consensual kiss of someone, or the alleged non-consensual kiss of someone else. They say non-consensual. He says consensual. Importantly, the person who was kissed has not spoken on this at all. And that's one of the interesting factors of the investigation. I don't know if you caught that or knew that.
No.
Oh, your video froze up for a second. There we go. You got wider. That was weird. Your video just adjusted and stretched you out. I don't know.
Okay, well, that's fine.
But okay, so this is a weird thing. In the Funimation investigation, there were 3 incidents, right? There's the twins in the hotel room, which is funny, but there's the jelly bean, and then there was an alleged kiss at Funimation Studios of this woman, and I won't say her name. It's out there. People can go find it. They probably already know. But she was a Funimation employee. Vic says that's a consensual kiss, but it was reported as a non-consensual kiss. The interesting thing is the person he kissed did not speak to Funimation, including for the investigation.
Yeah.
And Tammy Dembo, who did the investigation for Sony, she wrote the affidavit, and she kind of tried to write it cleverly, but she leaves that person out of the people she talked to. And it's like, wait, so how'd you investigate this one? I mean, you said you did. The only person you talked to about it would have been Vic or Monica, as was in some emails. Monica talked about that situation with Tammy Dembo in an email, that they would talk about it in their meeting. So it was like that type of stuff was just so frustrating, because it's like, wait a minute. But again, so you, Monica, have talked to this person about 2 specific events, one that involved you, one that didn't, and you left out an alleged assault, which, if you're reporting bad things that someone did, like that seems like the one I would go lead with. I would use the other one to maybe support that made you uncomfortable after the encounter that you had, or something like that. That's me, though. I don't know if you had any sort of opinion on that.
You know, I don't really have any particular opinion on any of that, but I totally understand Vic's frustration from his point of view about a lot of this, because it feel, you know, based on what's going on, and based on, you know, I'm a bit skeptical of the Me Too movement. I'm a bit skeptical of a lot of this stuff, and some of the stuff that was there just seems like the jelly bean thing really got to me. I was like, you got to be kidding me! I can't believe we're mentioning the jelly bean thing. I was like, I believe it, and I just don't care. Really, this is grounds to be upset about something. Really,
Right.
I mean, if you really pushed a woman to a bed, that I understand, but the jelly bean thing got to me a little bit. But I totally understand from Vic's point of view why he feels as frustrated as he did. You know, he had a good career. He was successful. He was going to conventions. People were coming to see him. People were asking for his autograph. He thought that he was friends with these people. Apparently, you know, these events happened, and for 10 years or whatever, these people were still friendly with him and, you know, joking and whatever. And it's, you know, it feels like, from his point of view, just a bit of a surprise. Like he didn't see it coming. It feels like a little unfair.
Mm-hmm.
And so, you know, I've never met the man. I don't know what's really going on in the real world, but I can sense his frustration from it all. It feels a little bit like Funimation was, based on their review, they were looking for a reason to get rid of him based on the Me Too. It looks like they were trying to virtue signal. Now, whether or not that's true in reality, who can say?
Right.
But it looks like there was a Me Too thing, and they wanted to show Me Too, and so they stood behind their people on somewhat dubious allegations that don't seem to really pan out based on things that happened.
Mm-hmm.
And so I understand why the Vic supporters feel the way they do. I understand why Vic feels the way he does. You know, I understand that frustration. I'm a little bit less able to understand the frustration of Monica and some of the other people there, and their frustration, a little bit less able to feel what's going on. But then again, you know, maybe they really were hiding this deep inside themselves for 10 years, and they just felt like now was the opportunity to reveal it. Maybe that was what's really going on. So trying to figure out what's really true in reality is one problem,
Yeah.
but like trying to figure out what's going on in this legal system. And it's one of the benefits of the legal systems. Like, we have a process, right?
Right.
And we have rules to follow and try to figure out what the truth is, for better or worse. And so, I feel like so far, the correct legal result has emerged from the process. What might be true in reality is a whole nother problem. And I can understand why he's frustrated by that.
Yeah. Well, we'll see. Like I said, ultimately we'll see what happens with it. That's the cool thing about our jobs, right? Is we get to watch all this and see what the end result is.
So in the event that it goes significantly unwell for Vic on appeal, how's that going to work out for you on covering that?
I don't know. I mean, like I said, I'm kind of been rather pessimistic. I think to some people's chagrin, rather pessimistic about the appeal. Of course, I'm hopeful that it will go well. I know that there's little chances here and there that it can, but at the end of the day, it's gonna happen one way or another. And if people, if that makes people mad, I mean, I'm gonna report on what happened. We'll go through it. I'll talk about where I agree and disagree with the appeals court, and then that'll be that, and if that, whatever that resolution brings to people is what it brings to people. So, again, hopeful that it goes on. I also have an ulterior motive for wanting it to go on. I think that certain people on the other side of this will melt down. I also think that Law Twitter will be
that's true.
Ordering Kool-Aid.
The Schadenfreude is real. I can't deny that. Yeah, I understand.
Yeah, and if they have to drink like gallons of Kool-Aid together, I'll laugh a lot at it.
Yeah,
but
the Schadenfreude, I totally understand. Yeah, I get you.
So, but it is, at the end of the day, I hate the expression, but it is what it is. And, and we'll cover it, and then we'll cover what happens next. And, hopefully it's been 18 months. Hopefully when the lawsuit calms down and people get resolution, I think that's an interesting time of lawsuits that gets overlooked, is what happens when people are out of this thing. And, when people get resolution, maybe we'll see something spring up from Vic's side. Maybe we'll see some interesting developments at Funimation. There have been some interesting developments in that many of the people involved in this case no longer work there. Scott Barretto, who provided an affidavit, doesn't work there. Tammy Denbo, who did the investigation, no longer works there. Evan Stone, their in-house counsel, and Notorious. I don't know if you're familiar with Mr. Stone being in the IP sort of segment, but he's on an eternal crusade against copyright, or against pirates, I should say. And he has some pretty interesting cases out there, but he's no longer with Funimation either. And those were all quiet happenings that occurred over the past, I don't even know when they occurred, but over the past 18 months. At some point. So I'm interested to see if Funimation will continue to stick by Jamie Marchi and Monica Rial, or if they will be publicly removed, or if they will be quietly given less and less work. I think obviously those are the three options. They'll either continue on or they won't. And if they don't, it'll either be public or private. But I'm curious to see how that plays out, just because this has been such a big thing for them, that has involved a big part of the community, and lots of press regarding Funimation as well. So they may not like it. They may not care. And so I'm curious how that plays out, in the future also. But,
okay.
But did you have any, before we move on from the Vic topic, I was watching your show about the brief. I wanted to clarify one thing, and it was at the end, which I saw your brain break from a comment from the chat.
Funny.
It was very funny. And I just wanted to clarify what they were talking about is it's articulated in Vanderlyn and V. Kahn, which was it was actually penned by the Chief Justice of the Second Court of Appeals, and it was the idea that if two parties are the only two parties with knowledge of an event, then they can infer malice, actual malice, because they know that those two parties know the truth. And so that is what they were trying to communicate. And so I think where people go with that, and this is where I go too, is that Jamie Markey hasn't alleged that anyone else was around or present for the hair pulling thing. So if Vic shows that there are factual statements in there that are false and therefore defamatory, then they can infer reckless disregard or knowledge of the falsity because she would be the only party with knowledge there. The counter argument would be her perspective of the events is different than Vic's perspective, which was brought up in his deposition. And that those, sorry, I didn't mean to.
There's also a potential point of distinguishment from the Kahn case. So going to the humor of the stream, the way that they phrased it, was a little bit off. And so I went on this little tyrant about how you and I are totally hoes because we know facts and whatever. It's like, it's not going to end well. Yeah. But then someone said, oh, two people in a room. I'm like, oh, okay. You mean the Kahn case because it wasn't phrased well in the first. But on the legal angle, the way I read the Kahn case was that the Kahn was making a more definitive, this is a potential issue.
Sure. Yeah.
Kahn was making a more definitive claim. He was saying, I would have never said this to this person. I would have never made that statement. It's just no possible way. And so there's a more direct statement. If she says, I did it, and he says, that would never happen. A potential point here is Vic was more ambiguous in his responses. It wasn't
conciliatory is how I categorize it.
It wasn't well, I would have never pushed her to a hotel room. If I was reading Vic's deposition before this stream, and trying to look for this exact issue. And it's like, well, have you ever been in a hotel room? Well, I can't remember because we've been in so many hotel rooms. It was a little bit more ambiguous of I can't remember. I don't know. I wanted to apologize. So it wasn't quite the sharp contrast that was in Kahn. So I don't know the degree that makes a difference, but it's a potential factual difference that might lead to a different conclusion.
Well, I have a famous moment, watching the depositions, specifically Vic's deposition. Now, in my defense, it was broken up.
You watched it as it happened?
No.
Oh, you watched the video of it. Okay.
I live streamed the recorded videos of it with commentary, and I had the video in 4 segments. I think it was 3 or 4 segments for Vic's, and I swapped. I started watching the one segment out of order. It was the last segment. I started watching 3rd instead of 4th. And so, but it made for a funny moment, and Law Twitter has latched onto that moment a lot, and that's fine. Egg on my face for the tech error, but it's the part where Sam Johnson is asking Vic about Jamie Markey's hair, and I said, just say you never touched her hair, please, right? And he said that he didn't pull it. He bounced it or whatever. And I was like, no, but what I didn't know was that this was actually a re-ask of the same question from the end of the prior video. And he had kind of clarified it but it's still true. All I wanted from that was him to just say, no, I didn't, or I don't remember ever doing that. That's not something I would do, kind of like what you were saying. And I think if there is a specific place where, because I thought Vic did pretty well in his deposition for the most part. I thought he did well. And, but if there was a specific place where all I wanted on earth was for him to just say, no, of course not. That was it. It's like, just say no there, please.
Yeah.
it would solidify things, but that's clients, right? And that's when you deal with people. You've got people, and people are people. so to speak. But anyway, all right. Well, did you have any final points you wanted to put on the Vic stuff?
Not really. And just to say that I do appreciate all the criticism that I get, because hopefully it makes me better. And it's one of the reasons I spent some time responding to Law Twitter's comments. I made a whole video about responding to their comments because I thought they made some valid comments. And some of the Vic people have made comments, and hopefully it makes me better.
Sure.
So I just want to say, for all the legitimate criticism that's been had and people have been responding to me with politeness and care, thank you. Makes me better.
Well, we need to get you some illegitimate criticism then. We need some of the fire. Yeah. We need some of the No. Oh, one thing, what was I going to say? It was in regards to filing the brief. But
I'm not God. I don't know everything. So I try to remain, I try to admit to areas where I'm ignorant. I try to admit to areas where I don't know things. And I try to express confidence only when I have confidence. So
this is why
maybe it's a weakness. Maybe it's a weakness, but it's what I try to do.
This is why you're not on Law Twitter though. They are always right. No, I'm kidding.
Yeah.
No, so I did want to say thank you for the very fair analysis of the brief that I wrote.
I thought it was very, very good. I as I said in the stream, I thought it was the best thing that Vic has had on his side so far.
Well,
I thought it was a very good, very solid, well footnoted, well reasoned. I did like the mirroring from the introduction to the conclusion. And Law Twitter was super salty of me. It's like, that's basic English writing. I'm like, yes, but
why didn't everybody do it then?
A lot of people don't do it. I was like, so this is a low bar to clear. I'm like, maybe, but I've read a lot of briefs and not so much. So yeah.
Yeah. Well, I appreciate it. All I ever ask, my work isn't on display for everybody for the most part. So all I ever ask is, that people give me a fair read, because I do try to give other people a fair read, as much as possible. But that being said, I was really appreciative that you did it. I am working on getting it filed. I don't know if I'll be able to or not. I have to get someone to wave me in, which I think is weird. So you read my first brief. I did refile the brief, or attempted to, and changed it to represent myself as a Texas business owner, and go proceed pro se. And the appeals court says that I still have to be waived in pro hoc vice to represent myself pro se, which I think, I wanted your opinion, because that doesn't seem right to me. Because if I take that to its logical conclusion, now I know this is different because it's amicus or whatever, but the way they cite the rule is that I can't appear as an attorney from another state. I can't appear even on my own behalf in a Texas court without pro hoc vice. So that means that if I'm sued in Texas in small claims court, or if I get a speeding ticket, that to represent myself, I would have to waive in. I'd have to be waived in pro hoc vice. And that seems like that is not a correct reading of that.
Yeah. I think the difference is in the amici versus the party. And I think it does actually make a material difference, because if you're an actual party, the idea there is some sort of due process issue. We don't want to forcibly impose on you. You should have the right to go it alone if you want. You should, maybe you have the right to an attorney if it's a criminal case, or you can have an attorney if it's civil. But if you want to go it alone against the government or against the other party, there's a due process issue. We can't force that upon you. What I say is the fundamental point of an amicus is you're trying to illustrate the law and what the law is, right? So the court has an interest in making sure that people are minimally competent to speak to the law, and the idea that any random person could just file an amicus isn't in keeping with that, because it's not an issue of opinion, or I feel like this, or I really wish it. It's not like writing a congressman of like, I'd really like, this thing to occur, and, this would be nice. It's like, no, it has to be a reasoned, articulated, educated opinion. And so it has to be from an attorney.
Sure.
And And so, the fact that it has to, I do think it's slightly BS. I agree with you partly that it's slightly BS that there's not this more global admission, particularly in federal court, where I think it's particularly BS.
Right.
And this is a little bit off field, but it's
No,
a
go
sticking
for it.
point for me. It's a little BS, but when I was admitted, I don't know about you, but because different states do it differently.
Sure.
But when I was admitted into Virginia, I was sworn in by the Virginia Supreme Court.
Mhm.
All right, I was sworn in by the Virginia. I went down to Richmond. They were there. They swore me in. It was great, and I was instantly admitted to every single court in the state. It was fantastic, and I'm admitted to the U.S. Supreme Court, and I feel like that should just admit me to every single federal court.
Right.
It's the same principle, but no, it doesn't work that way. You still have to be admitted everywhere. I'm like, I got cheated out, man. Why did I do this? Right.
Yeah.
So it's a little BS because I thought it was well reasoned. It was well argued, well articulated, well laid out. But the rule is in place to protect them from the incompetent, even if that's not you.
Right. No,
I
get it, and I agree that is a good reasoning. My issue being pedantic and being a lawyer is the way the rule is written.
Yes, I agree with that. Yeah, I understand that.
It's like if I apply this logically, and I don't think they would make me apply it logically, your ruling here would suggest that I have to hire someone to help me represent myself in like a petty traffic court, and that doesn't make any sense. But I'm looking for someone who will waive me in so I can file the brief, or who would file it on my behalf. But I don't want to ask someone else to turn in my work, so that's a little bit much. Right. But I'm looking for it.
I don't think the courts are particularly thrilled with the average pro se.
Yeah.
Just in general, I think if courts could refuse all the pro ses ever, they'd be thrilled.
Yeah.
But there's still this due process problem. They probably can't do that. So it's like,
right.
Well, we might have to let some people who aren't attorneys, actually talk to us occasionally, but
yeah,
keep it to a minimum.
But it's a fun adventure. But I got, I wrote the thing. I attempted to file it. I'll still try. But, convincing most of the attorneys I know in Texas are working on this case. So it's a little hard to find someone who will vouch for my, my ability.
Sadly, I'm not admitted in Texas yet, so I can't help you out on that one. So sorry.
The dumb thing is I should have applied for admission to the Texas bar because I've been practicing for 5 years. I should have done it earlier this year, but I wasn't with COVID. I wasn't even thinking about it. I don't know if they would have gotten around to it anyway, but I'll probably do it after this stuff. But just to have it because I have family in Texas and I'm down there with some regularity. But that being said, if I have a lead on a couple people who might do it, so I'm working on it. But let's start talking about there's a chat from Bad Vibes. Says, in my opinion, for TCPA, Kamehacon should have been sufficient on its own. The other conventions were listed by the defense. However, any other hearsay statements of individual cons would have made a bigger mess. Maybe, but I think the problem is that by the time they got to the Kamehacon discussion, everybody in that courtroom was flustered, like myself included, and I was just in the audience. So I just don't think that the argument about Kamehacon got articulated very well. And I wish Chup would have taken maybe a second look at it. But I think what he did, and maybe he did or didn't, but I think by the time he went and reviewed everything, he goes, you know what? I've dismissed all this other stuff. It's a lot easier for me to just dismiss these other things. And they're going to appeal it at that point. And if it comes back, it comes back.
I think that's probably true.
Yeah. But I do think the TCPA should have gone through on Kamehacon alone. I don't know how much actual damages that would end up being, because he did go. So they'd be small. But at least the case would proceed on that point. But, we have what we have. But Vic is obviously not the only thing happening in the world today.
Yes.
There's a bunch of stuff going on.
Yes.
And one of the big things, I've only talked about this once. I don't know if you've talked about it. You mentioned it when I first was emailing with you. Was the Fortnite case, Epic Games versus Apple.
Yeah.
And the injunction finally came back, the ruling on the injunction, and they granted it against, or they denied it against Fortnite. So Fortnite is off the App Store. But they granted it on the Unreal Engine.
Right.
So Unreal Engine gets to stay on by court order. Fortnite is toast. Presumably, Fortnite can cure their code, roll it back, and remove their purchases and get back in compliance, and maybe go back on the store. I don't know if Apple would let them at this point, but that's been the presumption. What do you?
What I think ultimately is, I think there is a potential antitrust issue here. The way that Epic set it up seems very odd to me in the way that they pursued it, because they could have pursued it without creating this contract breach, which sort of complicates issues in a way that's unnecessary. They could have just brought the antitrust, which is restraint of trade. So the idea is the Sherman Antitrust Act just basically says any agreement that restrains trade is illegal, right? It's Section 1 of the Antitrust Act.
Right.
And so, okay, it's like, all right, so you are preventing anyone from opening a competing app store on your platform. So that's a restraint of trade, unlawful tying. So you could have brought the naked antitrust case. But for reasons that are not clear to me, I still haven't figured it out.
I have
you
thoughts
like
on
you induced this contract breach to bring the antitrust. I'm like, I don't quite understand why.
My thoughts on it, for better or worse, I think what they were trying to do is enrage their massive audience against Apple, for whatever reason. It's not a legal strategy of any sort of merit, but it's for whatever reason it's a PR strategy, because they go, all these people love playing Fortnite. I mean, I don't play it, so I don't really care, but all these people love playing Fortnite, and if we get Apple to buy, and I think this, by the way, they set up their purchases to be $1 or $2 cheaper than Apple's as well, on their in-game store. If we do this, we can show everybody that Apple is the bad guy taking us down, even though Apple's argument is going to be you breached your contract, which was really easy for you to follow, that you've been following, and that's why we took you down. But the public is going to see Apple being mean, taking down Epic, is what their thinking is. And then the other thing I think maybe they wanted to show was how much they got a tally very quickly of how much money was being left on the table for them by not being able to have trade. By allowing the in-game store, they get a bunch of purchases that flood in, and they can tabulate that revenue, and maybe at a future hearing say, look, in just this many days, this is how much revenue we're talking about. This is how much trade is being restrained. That's my only thoughts on it. Again, I think it complicates things and maybe isn't the right move, but it's what I don't know if you have any response to my thoughts, but
yeah, I think your idea makes sense of why they did it. Your concept of why they did it makes sense, but their concept of why they did it doesn't make sense, right? It's like, if their idea is like, we want to inspire outrage, it's like, well, that's interesting and all. As big as Fortnite is, Apple's bigger and much more powerful, and so our people are really upset, and they're gonna show you to be the evil company. It's like, yeah, I'm not really seeing that working as a strategy. You may have overinflated your importance, Fortnite, a little bit. No matter how big you are, this is a $2 trillion company.
Yeah,
trillion with a T, trillion. It's kind of a big deal, you know. So,
yeah. Maybe you've heard of it. They have phones.
Maybe you've heard of it. So yeah, the way they set up this case seems very odd to me.
What do you think on their chances, though? Because like the interesting thing is, I guess in their pocket, maybe this is part of their strategy. Maybe it's to piss off Apple a whole bunch, but then go back and comply and have Apple not let them back on the store. Like maybe that's Maybe, but that I don't know that helps them. But
Well, if they don't let him back on the store, there's some sort of retaliation issue that might be interesting there.
right. Yeah, I guess. What do you like about their chances though? I mean, like ignoring the odd sort of procedural setup we have, just on the naked accusation that Apple is restricting trade on the platform. What do you think about that? Because
Well,
it's
there's
something.
there's a problem with the legal theory, because the idea is, if you create a platform that's a brand new platform that you have to allow competition on that platform, is a bit odd if you globalize the principle.
Mm-hmm.
Because if you globalize the principle, that would suggest that, BMW, when they're producing their in-unit stereo, has to allow competition
Right.
on that platform, right? They have to allow competition there too. The most extreme version of that on the complete other end is, assume that IBM, when they invented the PC, says, you have to, there's only one app store on the PC. If you want to buy any software, if you want to install any software on Windows, it has to be through our platform and nothing else. So does that fly in the opposite extreme? So we're somewhere in between those two things, but there is a problem with the limiting principle. It's
Mm-hmm.
like, if Apple has to open up their iOS device to competing app stores, what is the limiting principle of where does that stop and where does it start? That is not obvious to me.
Right.
And so if you can't identify the limiting principle, then your odds of success basically drop to zero, because no court wants to leave things open. You got to be able to answer, like, where does it start and where does it stop?
Right. And the interesting thing, going to your BMW analogy, is I think even if you're ordering a BMW though, you can put in a competing speaker, like an aftermarket
Sure.
speaker. So but that's not that maybe, and that's the problem with analogies in general, is that they're never perfect. But maybe the better analogy is can you put in a different navigation software, or can you put in Mercedes, for example.
The specific issue wouldn't be, can I put in a new head unit? The specific issue is, given the BMW head unit, can I force my app store onto their head unit?
Right.
And maybe that's too specific, because your analogy of speakers is reasonable, because why can I install different speakers and not put a different app store on the BMW created nav unit? But what is the limiting principle there is a problem. And I do like some of the analogies, because it's like, what level of analysis do you put this in? Because if you think of it as a payment processor, if you think of it as a payment processor, if you think about the real world, it would be very odd to say the literal physical Apple store that you can go into. I don't know what payment processors they use, but it would be very odd to say, well, you must add in these additional payment processors in your physical store.
Yeah.
You only use these banks. You got to use these other banks. And Apple would be like, what? And there's something there.
Yeah.
That makes sense.
But of course they do. Well, I guess I don't know who processes their payments. It's probably just one bank, but they accept multiple cards.
Sure.
They may also have PayPal and Stripe. It's hard to say, but again,
I couldn't speak to whether it is true, but let's just assume, arguendo, as we love to say.
Yeah.
Let's assume they only accept MasterCard and Visa at Apple stores.
Yeah.
And then Amex says, that's not fair. You must accept Amex at your stores. I don't know, man. That seems a little odd.
Yeah, it's weird. And I think, even if they said we only accept Apple Pay, it's like, okay.
Yeah. It seems a little odd.
That's even more like it. But at the same time, Windows got hit years ago because
they did it because they put in an order that was never actually enforced.
Right. But the idea was, you can't ship computers with only Internet Explorer.
Right.
And it's like, you must install Netscape. And Microsoft's like, but no one wants Netscape. Nobody wants to use it. And they're like, too bad, you have to do it. So there's like this, I agree with you, like the logical extent of it seems really weird, especially today, because you've got PlayStation and you're not forcing Sony to have a competing app store on a PlayStation.
Right.
You got Xbox, same thing. You can't force them to install Sony's app store onto an Xbox. So
it's a restraint of trade because PlayStation has PlayStation exclusives that aren't on Xbox. That's a restraint of trade. When you try to apply the principle and you try to globalize it out, you run into problems.
Yeah.
And I tend to think, I tend to try to look for limiting principles. It's like I can't find one. I don't know. So I'm skeptical, but it's an interesting idea if they can develop it.
Right.
But I don't know, man. I'm skeptical.
What do you think about let's see. You had some words for the Flynn case.
Yeah, dumpster fire that will never end.
Yeah. And do you genuinely think it's never going to end, or do you think it's going to end after the election?
Well, it depends on a couple of things that are factual predicates, because I think Sullivan, the judge, is trying to buy time on to force Trump to pardon. So if Trump loses the election, then he can pardon up to January the 20th at 11:59 a.m.
Right.
And so the question becomes, does Trump do that? Because that puts Sullivan off the hook, and it's like, well, there's nothing I could do because Trump pardoned this.
Yeah.
This is a travesty of justice. There's nothing I can do about. I think that's what he's looking for. But assuming that Trump either wins re-election or, having lost, decides not to pardon, I don't know what happens next. I have bet Viva Fry that he won't grant the motion to dismiss.
Okay.
So we'll see. That is my bet, that he will not grant the motion to dismiss, and he will go to the sentencing hearing, and DOJ may or may not participate. I don't know. Flynn's lawyers, of course, will participate. My prediction is, in the end, that he will find him in contempt, because why not? He will probably max him out as a traitor to all that is good and right and decent in the United States. And then we're back to appeal again, and blah, blah, blah. So that's kind of where I see this going, based on the 5 hours that I listened to the oral argument in the motion to dismiss. I listened to 5 hours of oral argument, and yeah, it was painful.
I have a visceral reaction to the idea that when the government is done prosecuting someone, like, and they just say, you know what, actually, we don't want to do that, that they can be forced to continue that.
Yeah. And then of course there's this, there's also the obvious thing that happens, the implied thing, right? Which is Trump loses the election, doesn't pardon, Biden becomes president, appoints a new attorney general, new U.S. attorneys, and what do you know? They suddenly feel like we shouldn't dismiss. Right. What are the odds?
Yeah.
Right. So then we're like, oh, okay, well, since you've changed your mind and you've withdrawn this motion that I've kept pending for 6 months for exactly this reason, I guess we'll keep going on.
Yeah.
It's like I can see where this is going. It doesn't take a lot of forecasting.
All I know is I don't want to be writing checks to Flynn's lawyers, because those.
Oh my God.
That will be the most expensive lawsuit ever, and because it's already got to be astronomically expensive, because these are novel issues.
They are novel issues,
and they're complicated, and they're pretty important and impactful. I mean, his liberty for a significant amount of time is on the line. You know, it's not a traffic ticket that he's accused of. So he's if he loses, he's going to prison, with a serious crime. So I'm interested in how it's going to turn out. But
the legal issue is fascinating, because the way Nate Brody puts it, another lawyer who I like very much, who goes under Nate the Lawyer, the way he thinks about it is you can segregate this between the guilt phase and the sentencing phase. And once the guilt phase is reached, the conviction, that the government really can't withdraw anymore, because there's nothing for them to withdraw. You know, the guilt is done. So the government can participate or not in sentencing if they wish.
Mm-hmm.
And because sentencing is ultimately left up to the judge, within the statutory range and guidelines and so forth and so on. So if the government wants to say we're not playing anymore in the sentencing phase, that's something they can do, but it doesn't deprive the court of its jurisdiction to sentence at that point.
Right.
The way the rule is written, though, and the way that the precedent seems to be guided does not appear to afford this latitude to the court. The way that I've interpreted the precedent, the best way, I think, is the rule is there fundamentally to protect the defendant and to prevent abuse by the government. So the idea is the government says we want to dismiss, and the defendant says no, I don't want to dismiss. Why? The government is moving to dismiss for reasons that will abuse my due process. They're doing so to gain more time, to bring new charges back, to just do whatever. So the government wants to dismiss, I say no. And then the court can say, okay, I grant your motion to dismiss, but with prejudice, screw you, go away forever. Is the way the rule seems to be there. The other thing that might be there is to make sure that the line prosecutor or the person who's signing this order is actually authorized. So if some, assistant U.S. attorney is signing this motion to dismiss paper, maybe it's because they accepted a bribe or whatever. So the other purpose of the rule seems to be to make sure that this is the authorized opinion of the Department of Justice to go up the chain, right? But that chain ends at the Attorney General at the end of the day. So if the Attorney General says, well, this is the opinion of the U.S. government, then that's where I draw the line. So it's to make sure it's the authorized opinion of the government is one purpose, and to make sure it doesn't abuse process. But neither of those are here. The Attorney General says, I want to dismiss. Mm-hmm. The defendant says, I want to dismiss. So none of those considerations are here. So as far as I can read the rule, as far as I can read the precedent, dismissal is mandatory. But what do I know? I'm not a federal judge, Nick, for some reason.
No, it's and that's my problem in a similar way to the case with the 3D printed guns, the CAD files, most importantly.
Oh my God, I could talk about that for a while too. Shit.
Yeah.
The Second Amendment is an area of particular interest of mine.
Oh, okay. Well, I'm curious because I was following that case with the 22 attorneys general who filed their case in the with Gruberger from New Jersey filing it in Seattle for.
Did you see the New Jersey Attorney General got owned by Texas?
Yeah, that was something that came out of left field for me because I was like, Texas refused to accept jurisdiction at the lower court level. So then I was watching the one up in Washington in the Ninth Circuit, and that case got really hard to follow because every filing has 22 idiots writing a document, and it makes me want to scream. And so the pacer list on it is terrible. Yeah. But so I'm following it along, and then suddenly I see a random news blurb that I missed from like 2 weeks prior, and it's like, oh, by the way, Texas Appeals Court says that they can sue in Texas. And then I read it, and I'm like, oh man, they were really pissed at Gruber.
No, they're really pissed. They're really pissed. The Texas Court of not the Texas Court of Appeals. Apologize. The Fifth Circuit Court of Appeals is the way to phrase that. The Fifth Circuit Court of Appeals, federal, said, hey, Texas, yes, you can haul the New Jersey Attorney General before your court and make them answer for this stuff. I'm like, so the New Jersey Attorney General has to come to Texas and say why banning guns is good. I'm sure that will end super well. Yeah.
But now we have these two competing cases now.
Oh,
and it's
in
like
different circuits.
Right. And it's probably going to end up with a circuit split. So I guess they'll have to go to the Supreme Court to resolve it. And I'm just over here like, wait, again, this is one of those things where the government says, you know what? Not only do we not want to prosecute this, but we want to go ahead and change the rule. And they're like, but you can't change the rule. And they're like, well, we literally are the only people who can change the rule. It's not even a legislative rule. It's not a law. It's a regulation. It's done by the Import-Export Office. And we're just clarifying. And they're like, well, you didn't follow the process. It's like, but they can follow the process, presumably. Like, they should be able to remedy that. But instead, they're fighting over it. And I get to this whole point where, again, okay, you got the two parties to the case, government versus defendant. They both agree, well, this is kind of silly, so let's not do it. And they're like, no, you must prosecute it. And for me, this is more egregious than Flynn, because like you said, in Flynn's case, they at least have gotten to that he's convicted. And they're now trying to dismiss between conviction and sentencing, where with the Second Amendment Foundation and I can't remember.
Defense Distributed.
They've never been, there's no conviction
Right.
that has even happened. They settled it out. And
Right.
And now we have some random attorneys general of states commenting on how a federal export matter somehow impacts their safety, with like the most weird roundabout arguments they could come up with. Like, well, someone might export a CAD file to another country where someone 3D prints a gun and brings that gun into the United States to kill a citizen in New Jersey. It's like, I mean,
well,
maybe.
presumably there was a crime at some point in that exchange, right? Yeah, so it's like...
But it's that case has been blowing me away. It's a procedural nightmare.
So the files, which are computer code, they're just code. Originally were restricted by the Department of State as ITAR,
right,
for international, dealing with arms, trafficking of arms. It's an arm. Code is arms. Okay, let's go with that theory for a while and see how that works.
Right.
Computer code is a munition. It's the same as a bullet. Okay, that makes sense. Question mark.
It's computer code, but there's the argument, of course, that computer code, and this is what's going on with Oracle and Google, right? Like, can you copyright code? Is this speech is a big question, right? Is code itself speech, or is it just a function of this other thing? And that's one question that's going on. But then at the same time, I mean, CAD files are code, but they're also they're like a created thing. Like you create a 3D model of the design.
Even if code as such is not speech, it expresses speech. It would be a little bit like saying English as such is not speech, but expresses speech.
Yeah,
which is probably right. So so there can be expressions of speech in the code, just like English or any other language for that matter. But yeah, it expresses, I mean, the way I put it on my channel, or if I said this before, it's like the Anarchist Cookbook or the Army Field Manual. You can print those, you can distribute those. Whether or not you can actually do anything in them is a whole nother set of problems.
Right.
But the idea, I mean, you can advocate illegal activity as long as it's not imminent. I can say it would be good to break this law. It would be good for people to riot and pillage and whatever.
You and I kind of can't, though, because we have an ethical obligation not to do that.
Well, we'll put that aside for the moment or whatever. That's fine.
But outside of that rare exception,
generally speaking, it would be good. I'll advocate it in places I'm not licensed yet.
Yeah, exactly. It would be good to kill a bunch of people in
It would be good if you're in Portland. It would be good if you're in Portland to pillage and commit arson in the streets. I'm not a lawyer there yet, so how about that?
Yeah, perfect.
Yeah, there you go. But yeah, you can advocate illegal activity as long as it's not imminent. You can encourage it, and so you can publish speech. And whether or not you can actually do it is a whole nother set of problems. So,
right,
I think the code expresses free speech, and these states say, well, people might print it off or make it. I'm like, okay, well, when they actually reduce it to a physical object, maybe that's not speech at that point. It's a physical thing, right?
Yeah.
So you can criminalize that. You could criminalize possession of it if you wanted to. You could criminalize the importation of it. That'll be fine. Hard to find the First Amendment issue there, but the actual underlying code, it's like, how does that work? Because if it can work for a gun thing, then again, where's the limiting principle, right?
And that's
the problem.
It's
that's
especially
the problem. So if you accept the premise that we can restrict the code that describes how to print a firearm because insert reasons, then why not whatever else we might want to print with 3D printer or a normal printer or whatever. You know,
Right.
where's the limit?
And it's especially troubling that they're doing this with something that has its express ownership protected in the Constitution. So,
Yes.
literally the argument is, if you can do this to a gun, what can't you do it to? Like,
Yeah,
there's
that's a very fair point. Since the Second Amendment has a special call out, this is speech related to a other constitutional amendment protected. So it'd be like speech related to religion. It has
yeah,
a special call out. So if you can do this to religious speech, then presumably you can do it to all speech. If you can do it to, speech relating to guns, then you can do it to all speech.
yeah, it's that's a troubling case. It's been going on forever. I haven't followed it in a while because of how tough it is. I'd love to talk to the lawyer for Defense Distributed, because that guy seems like an ass kicker. He's a professor somewhere too, right? Black something.
Blackson?
Yeah. He's and he seems pretty good. Also watching him like do hearings on his phone, going to in the airport lobby, going to another hearing in a different state. It's like, you're a busier guy than me. Like, I feel busy, but you make me feel unbusy doing that. But I'd like to talk to him. He seems like an interesting guy, and there's probably very few people more read up on these particular issues right now than him.
Yeah.
But
Yeah, Second Amendment has been a long interest of mine. I used to be a legal advisor to a gun right group, a couple of them actually.
okay.
It was something I studied extensively in law school. I read every brief in McDonald and all those Second Amendment cases. So something I know a lot about, something I'm passionate about, and I'm more than a little frustrated at this U.S. Supreme Court, because every year the U.S. Supreme Court takes 1, 2, 3, 4 First Amendment cases, like every year.
Yep.
And the Second Amendment needs a little love. It's a little underdeveloped. So how about let's take 5 Second Amendment cases every single year?
It's only
How
been a
about
decade.
that?
It's only been a decade. What are you even mad about? In that time, they've only dealt with like
I'm mad
50...
I'm mad about exactly that, the thing you just said.
How do you feel about US v. Miller?
I think Miller is just kind of a disaster. It can be read to speak for any proposition. U.S. v. Miller was only argued by one side.
Right.
Only the U.S. government showed up at the Supreme Court. Miller didn't show up; he was dead. So only the U.S. government showed up. Yeah, only the U.S. government showed up, and the case itself can be read for just about any proposition. Personally, I don't think Miller has much value, because it's a Shorrock test. It's read to be anything you want. So I kind of just ignore it completely, to be honest.
Yeah, I think it's a mess. I think what annoys me about it is the amount of crimes committed with fully automatic firearms is really low.
Negligible.
Right.
I think there's been like one total.
Yeah.
Ever with a fully automatic firearm. There's been like one with a fully automatic firearm. It's just not a problem.
We might have to. Yeah. I've been trying to put together.
And if memory serves correctly, I believe that one was also a police officer, and that's how I got it too. So I could be mistaken, but I believe that's correct.
No, I think you're right. In all honesty, it was something that ridiculous. But I've been trying to put together like a Second Amendment discussion with some good people. There's a lawyer down in Florida who I need to have back on. Her name is Kendra Paris, and she's been doing a lot of the red flag stuff down in Florida. The mental health stuff, and then taking the guns away. So I'm committing myself to put that show together, and you're going to get an invite to it, because I think you would.
Well, here's what I think. It's like we have the bare minimum right to keep case. That's McDonald. Mm-hmm. That's Heller. The right to keep it in a home. So we have the bare minimum right to keep case. The next logical step is we need the bare minimum right to bear case. Yeah. So it can be concealed or open carry, either one, in some context outside the home. Anything would be fine. We just need the groundwork to build on. And then probably the next logical step after that is presumably inside a business rather
Right.
than inside the home is the next logical step after that. And then we're maybe the next logical step after that is maybe like magazine size restrictions or something like that. But we just do not have the requisite underpinning for Second Amendment law. Like if you ask me right now to explain all of First Amendment law, it'll take about a half hour, but I can lay it out, because it's been fairly well defined.
Mm-hmm.
It's fairly well understood. There's a whole bunch of different tiers of scrutiny that are analyzed at different levels, and I can explain it. But I don't have that in Second Amendment law. And incidentally, for me personally, one of the things I do is try to analogize Second Amendment law to First Amendment law, because why not? It's at least to my mind written in similar language.
Right.
Because you have Congress shall make no law, right, in the First
Yep.
Amendment, and then shall not be infringed in the Second Amendment. That's at least close enough, in my humble opinion, to start making like parallel comparisons. And so since I have all this wonderful First Amendment law with this various tiers of scrutiny and various things, it's like, well, I can attempt to fit all of Second Amendment law against this pattern and try to figure out where this goes. And I need things that fit this hierarchy, and I don't have that to work with. So a lot of people on my channel will say, well, what do you think about the National Firearms Act? Or what do you think about the Gun Control Act? Or what do you think about this? I'm like, we're nowhere near to being able to answer any of those questions right now, because we just don't have the underpinning for it.
And I think that's actually one of the things that annoyed me. I liked Scalia in general because he's funny. I mean, even when I disagreed with him, he was funny and just a good writer. But that's one of the things that really ticked me off with Heller, is I think he dropped the ball on laying out what level of scrutiny should be applied to some of this stuff. Because I think
he avoided it.
Yeah, and I think it should be strict scrutiny. But he just he lays out that this needs to be determined and then doesn't determine it. And that,
well, he ultimately says it fails under any level of scrutiny, which is just wonderfully unhelpful, because the courts of appeals have been generally going under intermediate scrutiny, and that's been very unhelpful.
And but I don't think intermediate scrutiny has any place in the Second Amendment. Personally, I think it should be strict scrutiny.
I mean, I don't know if I go quite that far, because intermediate scrutiny does have a purpose, albeit limited, in the First Amendment context. So maybe there is something there in the Second Amendment context. So I won't go quite that far.
Sure.
But yeah, it's like we need to figure out what the strict scrutiny stuff is, what the intermediate scrutiny is, what the rational basis stuff is, and all the rest of it. And right now, it's just completely underdeveloped. And I have ideas of where that needs to go and how to do it. But the Supreme Court needs to actually hear some cases and actually write these opinions so we can build on some stuff.
Yeah, and the Supreme Court really dropped the ball with the New York case, in my opinion, with the transporting the gun. I get that it was interesting because when they did it, some of the commentators were like, well, they're probably just waiting for a better one. And then every other gun case that came up is like, oh, nope. And so that one to me was, again, this sort of clear indication of an infringement on your Second Amendment rights. Wait, so I can only bring a gun between my house and one of 5 ranges. What happens if you move? Like, what happens if you leave New York? Do you have to throw your gun in the garbage?
Well, well, yes and no, because I think the right way to do this is through increments. And if you could have gotten that case decided, which was rendered moot because New York went to extraordinary measures, which were really annoying, to moot the case. But if you can get that case decided, it's something to build on. So but then you say, what's the next logical step, which is what you always do. It's like, and then you can ask the next question. But I am very convinced that it's Roberts who's keeping it out of the Supreme Court. And my view on Roberts, and let me know if you agree or disagree. Well, my view on Roberts is I think he compromises what he actually really believes in some sense of duty of the court and its perception. He's concerned about the institutional legitimacy, and he's concerned that if he goes too far, the court will be perceived illegitimately. And so I think he compromises himself to maintain that. The other alternative interpretation is he's actually more liberal than anyone thought, and this is really where he wants to go. But
Right.
I'm of the view he's compromising himself out of some sense of. I think like his decision in the Obamacare case was rooted in not necessarily what he really thought, but out of a desire to maintain the legitimacy of the court. So that's
Yeah.
what I kind of think.
Yeah, it's and I'm not sure if it's legacy of the court that he's concerned with or legacy of the Roberts court that he's concerned with. I just don't know, but I agree largely with that analysis of him. And I think the Obamacare decision was indicative of that. You know, the court isn't here to rescue the people from their elected officials. And it's like, well, actually though, that's literally what the court is there to do. So that's a weird statement.
Right.
I mean, I get the sentiment you're going for here, Roberts, but if it's unconstitutional, then it should be unconstitutional, whether or not it's a consequence of our free and fair election.
And maybe this is too far afield for our current discussion. And if you want to come back to it later, let me know. But I'm unbelievably concerned about the packing of the Supreme Court. I think it is a complete disaster. I am utterly, well, I don't go quite that far, but I'm significantly concerned that it faces real problems of the solvency of the republic.
Mm-hmm.
I try not to be overly doomsaying, but I am really, really worried about, about what's going to happen if they start packing the court. Just by way of my biases. I mean, I'm conservative, but that being said, I don't oppose getting rid of the filibuster. I've thought the filibuster is stupid. It's just a personal opinion. I don't like it.
Yeah, I think so too.
If they want to admit Puerto Rico as a state, that's fine. I mean, it's got 3 million inhabitants. If they want to be a state, that's fine. Whatever. But the packing of the Supreme Court, it's like, I don't know how you come back from that.
Yeah, and it was threatened, of course, under FDR. And the threat alone, the impact of the threat alone of packing the court is stuff we still feel today in the decision-making process. With the Supreme Court started out kind of unfriendly to New Deal propositions, and then FDR was like, "You better knock it off, or I'm just going to appoint nine good union judges or whatever, and they're going to come in, and nothing you say will ever matter again." And suddenly they were all on board with almost every issue. And I think that the danger we've got with the packing the court discussion is that people are being sold right now on the danger is solely from Biden. I think there is a potential for Republican packing as well. I don't know that it's going to happen, but it's certainly a possibility.
I think you'd have to. Well, you'd have to in response, right?
Yeah, in response, it does. Now, maybe I have an alternative theory of the original Supreme Court, of what it was going to be, and I think Marbury versus Madison ruined it.
Okay.
I picture the Supreme Court initially as something more akin to the appellate court system that we have. That the Supreme Court was going to be a nationwide network of courts with way more than just 9 judges, and that they would not decide constitutionality of law, but that they would literally just take the individual issues and rule on them, and that we'd have a much more active and giant Supreme Court, but they wouldn't make sweeping decisions that made law from the bench. What do you think of my crazy conspiracy theory?
Well, first of all, let me just say I think Marbury versus Madison was correct. Personal opinion.
Well,
in terms of
we'll have to agree to. No, I'm just kidding. Go ahead.
The role of judges going into common law and going historically was even more power. Like a lot of things were created from the bench. You know, on my channel at one point, I read the first assault case ever. You know, from Scotland, from like 14 whatever. You know, the first assault case ever.
Sure.
You know, some judge created it out of nowhere. You know,
right.
In Scotland, and it's like, so the idea of judge making law was fairly deep. What I think is the Constitution Well, the Constitution is just another law, but it's a higher law, right? So we have
Hmm.
tiers of law, and the Constitution is at the top. And so if a law is not consistent with the higher law, it has to bend. So regulation bends to statute, statute bends to Constitution. So I don't really see interpreting the Constitution as any different than interpreting a statute when you're talking about a regulation.
Sure.
So um, I think the role of the Supreme Court is to protect our liberties against the majority, to protect majority rule. The entire point of the Constitution is to protect majority rule. It's anti-democratic. It's supposed to be anti-democratic. It's supposed to say, here's things the majority cannot do,
Right.
because there are certain things that are essential to individual rights, and that's the role of the court. And also, I'm a textualist these days. I was on team Scalia, but these days I'm on team Gorsuch.
Sure.
Gorsuch is the new hotness. But just trying to look to what was actually written and do that.
Well, what about the fact that constitutional review isn't in Article 3?
Well, yeah, it depends how you interpret Article 3, of course, but Article 3 does say that there shall be a Supreme Court which shall hear the legal issues, and so presumably that's part of it. So it depends how you interpret that phraseology, but I think it's consistent with Article 3.
I'm going with textualism on this one. It doesn't have constitutional review in there. I'm being annoying now.
That's fair. That's fair. We're having a discussion no one else cares about, but that's
right,
fine.
I know. It's my pet project. But the reason I bring it up is because in this weird back and forth of packing the court, eventually it gets ridiculous, right? Okay,
eventually I get appointed to the Supreme Court.
Right, eventually we all do. Everyone with a license would have, because they'd be running out of people. But you gotta wonder. Okay, so Biden comes in and he says, "Well, I'm gonna appoint 7 new justices, and we're just gonna steamroll them on these issues, and we're gonna solidify this stuff." So then people don't like it. They elect Barron Trump or whatever next, and he comes in and he says, "I'm gonna appoint 12 conservative justices," right? Where does it end if you start packing the court? Right now, it doesn't. Theoretically limited by the Judiciary Act, but the Judiciary Act may be unconstitutional in and of itself, because it presumes to limit a plenary power of the executive branch, and it's by limiting the number of Supreme Court seats.
Well, you could actually go one step different from that and say it limits a plenary power of the judicial branch.
Right. That too.
Yeah.
So it's weird. That's what actually has me worried about packing the court, is that what you said, it's a back and forth. If one side does it, the other side can do it in retaliation. And then we're in a cyclical dumbing where we're just electing people to keep appointing stuff. And I don't know how you overcome that unless the Supreme Court itself were to come out and rule against court packing, which would be weird.
Which you got to find out a way to do that, and good luck with that plan. It's a very tough legal analysis,
right?
And especially if you're originalist, because it's how do you say what the number should be? There's nothing to pin it to,
right? So that's that's a mess, man. I don't know. But I am worried about that from this election's perspective for sure. I do think it's a real risk. I was annoyed at Kamala Harris refusing to answer that. Or wait, was it Biden or Harris? Yeah. He just refused to address the question at all. And it's just say, you could even do a dodge, but just answer the question and say, look, we plan on abiding by the Constitution. And it's
the way I think about this conceptually is we have to split the difference between political and legal as wholly different concepts to my mind. The political power has been split unto itself between the president and the Congress. They have the split of political power,
right? Or
policy, put it in our way. The court does law. And for the way I explain this example, for just to bring it to me personally, if I were a conservative member of Congress, I'd be very unlikely to vote for, say, a 90% marginal tax rate. That doesn't sound like a thing I'd vote for,
right,
as a conservative member of Congress. That being said, if I'm a conservative member of the court, and they've already passed a 90% marginal tax rate, I'm going to uphold it because it's, even though it's not my policy, it's legal because
Yeah.
there's nothing stopping that. So that's the difference between policy and law, right? I shouldn't have my policy preferences. I don't want that, but law requires it. So do it. The problem with packing the court is it seems impossible once you do that to keep that separation.
Mm-hmm.
It just becomes another tool of power. It just becomes another political tool. It becomes another way for whatever group is in power to confirm its political priors. And that's not what the role of the court should be.
Right.
It should be, it's not an issue of what do I want, it's an issue of what is. And once you start packing the court and once you start playing the game, I don't know how you even begin to try to maintain that difference. And once you lose that difference, you're talking about threats of separation of powers. You're talking about threats of federalism. You're just talking about basically, I don't know how you come back. I mean, my level of concern could not be higher.
Sure.
It's apocalyptic levels of concern about what that means in the end.
Yeah. There's one of the viewers just mentioned we could have a constitutional amendment limiting the number of justices, and that's
which
about it.
Which I don't necessarily oppose. I don't even necessarily oppose like the idea of some sort of term limit as long as it's done fairly or evenly.
Mm-hmm.
So if they want to I don't know how they could possibly do it statutorily. I looked at the proposal from the House and it's like, no, that's not going to fly under the Constitution. I don't see how you can do it statutorily.
Right.
But if you want to do it by constitutional amendment, and you want to say, for example, whatever number you come up with, 9 or 11, and then you want to say every 2 years the term ends on a rotating basis, that's fine. So if you have 9, that would be 18-year terms on a staggered basis.
Sure.
Or whatever. And then you would always appoint someone in an odd number presidential year. That would be the rule. I'm okay with that. If you want to even expand the number of people on the court in an even way, so like we're going to add a new seat, say every 8 years or something like that, I'm happy with that, because maybe the court should be bigger. There's more for them to do, and they need more diversity of labor. That'd be fine. So if you want to augment it to 13 and add a new seat every 4 years or something, I'm cool. But you just want to give one party the ability to pack the court. I'm like, no.
See that you're giving in right now to the Westlaw conspiracy. Westlaw is like, we need to raise the price of our product even higher. And so what we'll do is we'll convince them to add more justices, so there's more concurring and dissenting opinions that we can publish, and therefore charge more. That's what's going on here. Westlaw is the shadow hand of government.
That's the first I have to say. I've never heard that one before. Are you sure it's not LexisNexis? It's got to be Westlaw.
It's got to be Westlaw.
It's Thomson Reuters.
Thompson's
Reuters behind it all.
I know they are, because I just renewed my subscription, upgraded it, and it costs double what I was paying. So now I hate them. Let me read some of these chats. Bad Vibe says, here's a different analogy. Shouldn't I be able to bypass Samsung Tap Pay on my phone? Can I use Google Pay? If options can exist that doesn't burden the host and manufacturer, I think that is a start. And again, that's an interesting analogy. One of my problems with Verizon when I was on Verizon was they were supposed to be the first launch of the Galaxy phone, the Samsung Galaxy phone. I was waiting for it, and Verizon had the exclusive on it, and they didn't release it. And it got delayed. It got released like in France or whatever first. And the reason was Google was releasing Google Wallet, and Verizon had Verizon Pay. And there was a dispute over whether or not Verizon could exclude Google Wallet from their Android devices. And that caused the delay. And I thought that was stupid, because who wants to use Verizon Wallet? It's not as good as Google Pay. It just never was. So that type of stuff is, but it's an interesting question of can they do that? And I don't know. They do it. Verizon used to exclude navigation software, but charge you $10 for theirs, where it was free with everybody else. They thankfully walked away from that. But RW Bimby says, Uncivil Law. brisket or pulled pork?
Wow. Truly pulled pork.
Mm,
But I grew up in South Carolina, so pulled
that's why,
pork. Yeah.
yeah. I'm,
Yeah.
I'm sorry for your loss. How is plotting to harm a government person different from actual group attack, blocking exits, and setting buildings on fire with government people in it? Okay, I think this is a
Okay.
clever way of asking the difference between Whitmer and Portland.
Well, yeah. Well, when you say plotting, that implies something different than what I was suggesting earlier, than advocacy,
Yeah,
right? So when you say plotting, that's conspiracy. Now we have a group of people, and at least an act in furtherance thereof,
yeah.
to form the conspiracy is a little bit different than saying it would be good to kidnap the governor. Yeah, that's a little bit different than saying it would be a good idea for people to do it. Yeah, when you have plotting, you're saying a conspiracy, and conspiracy is illegal.
It would be good if we brought back the hanging of politicians.
Yeah,
Robert
there you go.
Robert Stratton says we lived through exactly this with encryption during the crypto wars. It took
Sure
someone
did.
taking an illegal to export floppy of source code and publishing it in an OCR font in a hardbound book, and then asking for a ruling. Yeah, that was wild
Yeah,
times.
the crypto wars of the '90s and Phil Zimmerman and PGP and all that stuff. Yeah, I remember all that. The Clipper chip, all that good stuff. Yep, I remember.
Mithrin Emmer says Josh Blackman at South Texas College of Law in Houston. He teaches con law and property law. He's a defense distributed guy. Yep. CJ says cryptography. My first and second rights rolled up in one package. The United States Munition List sections 38 and 47.7 of the Arms Export Control Act. Holy shit. 22 USC 2778 and 2794 sub 7 category 8 auxiliary military equipment. Effing earn it. Okay. Mike Mysterio says, good evening, gents. A few things I wanted to ask about. 1, legality of the coin shortage / push towards a cashless society. 2, Pelosi trying to use the 25th to remove Trump. 3, have you looked any more into the Phantom Lord? What do you think about the coin shortage?
Well, the coins shortage appears to just be a natural consequence of a change in people's behavior, right? Because the way that coins are in circulation is by being in circulation, which is namely to say that people are going to stores and buying things and paying things, and sometimes with cash and sometimes with coins.
Right.
And they're not doing that. First of all, people aren't going to stores, period. And to the extent they are, it's much more likely to be credit and remote pay these days. So the coin shortage is just a consequence of the change of behavior. It's not, something more nefarious than that, as far as I can tell.
I just wasn't aware that there was a coin shortage until everybody told me there was. And I was like,
Yeah.
okay, I guess. Because
The bottom line is coins are not in circulation because people
Yeah.
are not in circulation. Yeah, that's what that is.
I don't like cash personally. I tend to use debit cards for everything, but that's me. I know I should like cash more, but it's just so inconvenient to carry it around. Like, what if you're at a water park and you get water on your cash? That's ridiculous. What do you think about Pelosi trying to use the 25th to remove Trump? 25th Amendment.
Yeah. So the 25th Amendment states that with the consent of the vice president and either the consent of a majority of the senior officers of the executive, which is to say the cabinet, or another body that Congress shall designate, the president can be removed. So the language of the 25th appears to say that Congress can designate some other group that they just create out of nowhere. They still need the VP to agree. So they can do it. I think that this is being done with Biden in mind, though, rather than Trump. I think the reason this is being done is so that they can remove Biden if he gets elected.
Yeah.
But
Do you think there's no way that guy finishes a term, right? Like, there's no way.
yes, well, all you need is 2 years and a day, baby.
Yeah.
2 years and a day.
That's
Yeah, as long as you get 2 years and a day, then Kamala can run for 2 additional terms. So the way I said this to my chat is like, do you think Kamala knows 3 USC 20 off the top of her head? And for those of you, yeah, for those of you who don't know the joke, 3 USC 20 is the law that says how to resign if you're the president.
Yeah.
That's why it's funny. So it's like, yeah, so all you need to wait is till January the 21st, 2023, and be like, hey, Joe, sign this paper so that I can be president for 10
At
years.
that point, he may not even know what room he's in.
Yeah, right. Yeah.
Yeah.
So that's a problem. The fact that people are willing to ignore Biden's mental defects is a little bit amazing
Yeah.
because it's clear. And one of the and I filmed a video about this on my own channel. I was like, I was critical of Trump on a purely tactical level because he made a mistake, in my opinion, by not letting Biden speak. Because the more Biden speaks, the more it's revealed his problems.
Yeah.
And so I thought he made a massive strategic blunder by not letting him talk. If I were Trump, I'd not use my time and just let him speak more, because they'll be
See
like,
what you have to say, Joe.
There you go. Yeah,
Tell us
say
about
what
it,
you
Joe.
gotta say. Tell us about it in detail, right? Yeah. So that, yeah, it was a mistake.
And speaking of your channel, I should probably announce that I put a link to it in the description. You guys should definitely go check it out. Go subscribe to it. Make sure you watch Uncivil Law's videos. Lots of topics that I don't cover. So definitely check them out, especially if you're into more, more of the ongoing Supreme Court legal analysis. That stuff is much more prevalent on your channel. So do it.
Yeah, the Supreme Court term, when the Supreme Court is in session, is my favorite because we try to do at least one oral argument every week and try to really break it down and really talk about what's going on in detail. And the Supreme Court is inherently interesting because it's the most inherently interesting issues, because it got to the Supreme Court for some reason.
Right.
The Supreme Court, except for original cases, which are very rare, is discretionary. So if they pick the case, it must be because it's interesting.
Right.
So like we can learn something from it.
Yeah, and the way my con law professor always described it is, these are the best con law students in the world. By function of where they are, they're the most qualified to comment about con law, because what they say is how it goes. So,
that's right.
So you should always pay attention, even when you disagree. All right. Well, I've read all the big chats. I've got a bunch of little chats to read, but it is getting late, so I wanted to let you know that you're welcome to stay, but if at any point you need to leave.
I'm doing fine.
Okay.
I took some caffeine before we started. I'm still good. I might have to use the restroom, but other than that, I'm fine.
All right, because my show goes long and late, and
I'm well aware.
I figured. But okay, I'm gonna start moving through these quick though. So, but feel free to jump in on any of them. Knight of Hopex says, this is the difference between a patent lawyer and a trial litigator, I guess. You don't seem to understand that the judge doesn't get to behave based on his or her personal biases, patience, respect, etc. That doesn't determine what is proper or improper.
I addressed that when it came up. Actually, I saw it and I addressed it at the time. But basically, to just reiterate, judges are human. Don't piss off the judge.
Yeah, and that's good advice, generally speaking. There are times when pissing off the judge is a tactical move. Those are rare. Those are rare. Judge Chump says, Nick, could you ask your guest to substantiate where in the filings he draws these massive leaps in logics and conclusions? He likes to refer to the record and filings, but it seems like he knows the record as much as Chup did. Not at all. Ouch. Well, I think we kind of covered that. And again, these are from a little bit earlier in the show, but we kind of talked about that with the idea that, if you're not aware of some of these factual issues, that could actually be a failing of the pleadings and the filings that occurred, because that's where you make the case. And one thing that's hard for people like me and the chat as well to remember is that we have seen all of the facts and we remember all of the facts. Not all of those facts made it into the filings, and the judge is not following along on Twitter and YouTube. And so that can be a very frustrating thing. Knight of Hopex says, Chup didn't follow the procedure of the court or the rules of civil procedure. He didn't understand the Rule 11 agreement. He didn't understand the TCPA. Law and justice shouldn't be just what's easier for the court to understand, half blasted on a Tuesday.
It's not Tuesday.
No, the hearing was that's what he was saying. He wasn't saying we're half blasted. I think he was saying Chup was half blasted. Wait, you're half blasted? I gotta turn up the octane with this Amroot Indian whiskey.
Sounds promising.
It's good. It's good. TLJ Screwjob says, wouldn't Jamie's story, which happened in Funimation's lobby, hold on, I'm trying to read while pouring, not being investigated be a weird thing, or would the appeals court not care? Like, wouldn't that help push it to passing the TCPA? I don't think so, because if it wasn't raised to Funimation, they don't have any duty to investigate it. Like, they just wouldn't have known it happened. But I don't know if you had any other comment about that. That just seems, yeah. I mean, if Jamie's comes, here's actually what bothered me the most about Jamie's story in the context of the case. It was at the hearing, and Judge Chup talks to Sam Johnson about the hair pulling allegation and the tweets alleging it. And then he says to Sam Johnson, and they have a little discussion. He's like, but, you know, pulling hair is a fact question. Because Sam Johnson says this is all opinion or whatever. He says, well, pulling hair is a fact question, right? And whispering something, sexual or not, into someone's ear, that's a fact question, right? Like, we can know if he whispered something. Pulling her in, that's a fact question. Sam Johnson says, yes, because those are fact questions. And then Judge Chup turns to Ty and says, well, what did she say? Like, what defamatory statements are there? And it's like, well, that one. Like, you just went through it. And then, again, and this is a part where I don't know if Ty was flustered or whatever, but he didn't just say, well, that one. He was trying to figure out if there was another defamatory statement. And I think that's the main defamatory statement she made. So,
one of the things in defamation is the difference between what was said and the pleaded truth, right? So if you make a claim and I say, well, the truth is actually this, does it actually matter? And so one of the things that strikes me in that exchange is, does it really matter what the difference between what they're saying is? So they say, well, I pulled my hair. So the idea is, well, I came in for a hug and maybe I leaned in because that's how you kind of do hugs, right? I lean in. And so maybe you could perceive me as, you know, and you kind of caught my hair maybe. So like, could they both be telling the truth at the same time? And it's like, yeah, maybe they could be both telling the truth at the same time from their own perceptions. And would it really matter if you believed one versus the other in terms of the facts? Once you accept the facts of what's happened, does the opinion change? And it's not clear to me it does.
Sure.
Maybe I'm wrong on that, but it's kind of
the mild counter, and it's not really a counter argument, but the one thing to consider, and I think this is where I got hung up on this, is at TCPA, as the non-moving party, Vic is entitled to the benefit of the facts. And so if there is a disagreement on facts, then, you know, Jamie disagreeing shouldn't have any basis on what Vic's version of the facts is at this stage. Now, it may come in later that they say, okay, well, you say you didn't pull her hair. You may have touched it. She says you did pull her hair. At that point, we're weighing out the differences between those, and does it matter? But if Vic says, she says I pulled her hair and I didn't pull her hair, then that's a fact that should weigh in favor of Vic at the TCPA stage, because all factual matters are resolved in favor of the plaintiff. So
the idea is, even if you assume every fact in Vic's favor, could she still come up with the opinion that she did? So even if you assume that it wasn't pulled, does it really matter in terms of her perception? Because her perception, according to her at least, is that it was an unwelcomed hug. She didn't want it. You know, it was creepy or blah, blah, blah. So if you assume every fact from Vic's perspective, you know, it didn't pull a hair, you know, it didn't sniff, but does it really change the opinion of the experience? It's not clear to me it does.
Sure. Yeah, and it's that's what I want resolved by the court. Like, that's one of the things that I would kind of like to know, because to me, if someone actually pulls someone's hair, pulls them in close, and whispers something in their ear, and that's an unwanted touch, like that's kind of a big deal. But if someone is, going in for a hug, which according to Jamie, she initiated the hug.
Yeah.
So if she goes in for a hug and he says, "Oh, I like your hair," and touches it, like it's such a different interaction to me that it matters dramatically whether or not, which version of those stories is true. So I don't know. You raise an interesting point though, and I think the answer to your question is yes, a court can do that, right? The question of, here's my ultimate problem with how Chup handled things is I don't know that he did that.
Fair enough.
And
yeah, fair enough.
And I didn't get that from the hearing, and I didn't get that from his written opinion either. And you touched on this in the video on the brief, where there's points where it's like, but he didn't actually flesh it out. He didn't say it. So maybe he thought this way. Maybe he was ruling based on this, but we don't know. And that is one of those problems that I had with the overall rulings that he gave, was I just don't know if you did any analysis at all. But yeah. Let's see. Flandre Scarlett says it's interesting to compare Rooster Teeth's situation versus Vic's situation. Rooster Teeth employees caught with many pictures from Catfisher and multiple women with DM receipts who posted them within days. Vic, nothing verifiable of substance released by accusers to this day. Yeah, that's and I think that's part of the public perception that weighs in Vic's favor, especially for his own audience. And for many people, that's where the most important stuff is. Now, you'll have to forgive me. Sometimes people ask me to do Kermit the Frog voices. So let's see. Kermit the Frog says, I swear to God, if Uncivil Hairline ruins my chances of getting in Vic's gay pants, I will end him. And then he says, I'm so fucking sick of those whores ruining our video games. I remember once when my daughter said she loved Zelda. I hit her. She deserved it. Go cook or go clean or something. Video games aren't for you, gamer girl. Wait, what? What is happening? LaPierre Hammer for prison says Miller was a literal show trial. Judge Ragon wrote the NFA. No recusal. Then denied Miller his choice of plea and attorney. Justice Black voted for it and didn't recuse. Do a video on the massive abuse of the law before it got to the Supreme Court. That'd be interesting. Mario Carter 13 says disappointed by Whitmer Inglourious Bastards remake. Zephael says great to see two cool lawyers together at last. Hey, thanks. Tony Neves says even the fly left Obama and Hillary. Hashtag Walkway 2020. McWhoopin Game says, hey Nick, I was wondering if I could use your grifting powers to shield my gaming channel. I'm looking to get more subs and views for it. Guys, you can go check out McWhoopin Games. McWhoopin Games. Bloody, I assume it's on YouTube. Bloody Bumper says, is the guest from Cincinnati?
No, I went to law school in Akron, which is why I mentioned eating at Buca de Beppa there, but no, I'm not from there.
Sure. Vanish Mantle 4 says, still waiting to get the chance to talk to Drex. Sent at least 4 to 5 emails like 6 months ago. Guess I've got 3 more to go. LMAO. FYI, email is the same as my YouTube name too. I'll find him, Vanish Mantle. I think Drexel is going to be here for a lot of time next week. Like 4 or 5 days. So I'll let you know. Melissa Boomer of the Night says, cheers to our guest. Virginia Barr is no joke. Wesley de Aguayo says, Uncivil Law, give us the eyebrow. Tony Neves says, recently with the San Japan fiasco, there was also evidence that showed the chair of San Japan was part of the group of con organizers trying to ban Vic. That's actually one of the frustrating things about this. There is a convention Facebook group called We Run Anime Cons, and I was told about this from people who were in it but were subsequently banned, and I was trying to get screenshots from it because there was allegedly the reason he was banned from conventions over a several day period was intentional, to try and make it look not organized. But I can't verify that. I just have allegations from people who were in it, but no screenshots. And so I was spent several months trying to get that, but was never able to. Chris Tuckerson says, since Von Dragon wants to keep being a predator, I'm giving Chris Hansen and the Florida Police Department a call ASAP. Who's Von Dragon? No idea. Phoenix Lord Asterman says, felt to me like Chup not taking the binder through tie off, telling him not to object was the end of all hope for the case. Yeah, that was an interesting moment. What do you feel about that moment in the record where he says, the way he said it in the record is, would you please stop standing up? Or you need to stop standing up or whatever. But it was right after Ty had just issued like 5 objections, and he basically said, stop objecting. I thought that was a little improper personally, but
it's a fair point.
Yeah. But they didn't really raise that on appeal.
Yeah.
And I don't know if they should have or not, but that just seemed like, I think I would have thrown that in if I were Monday morning quarterbacking the appeal brief.
It just felt weak. The appeal brief felt weak.
Sure. Kalinka Pavlova says, did you see that the Me Too movement is associating itself with a monster, specifically Medusa, and will erect a statue of her holding Perseus's head? Lol. Yes, at a courthouse, no less. Did you see that story?
I did not.
There's like a 9-foot tall Medusa holding the severed head of Perseus that's going to go up in support of the Me Too movement, I guess. I guess that's a supporting thing, but that's weird.
What's the connection there?
Somehow, I guess because since Medusa is killing Perseus rather than Perseus killing Medusa is why they're doing it. I don't know.
Okay.
It doesn't make much sense to me because that's not the story, but that's the statue they're going with. Backgoat says, not enough grifting going on around here. Tony Neve says, Loke used the SCOTUS case on DACA for prosecutorial discretion in R.E. Flynn.
Yeah.
Amateur Ant says, Trump needs to pardon Julian Assange and Snowden. I agree on Snowden for sure. I'm maybe there on Assange as well, if he's not insane yet. I heard he was kind of going crazy.
Ironically, I'm more there on Assange than Snowden.
Oh, okay. See that now I don't know as much about Assange, and maybe that's the problem. But so you're not full, like I'm fully in favor of pardoning Snowden. So
yeah,
I'm curious what your hangups are on him.
Well, my hangup is fundamentally like Assange's issue is, as far as I can tell, he's a journalist.
Sure.
Right. He's just reporting things that are told to him. And so just merely reporting things that are told to him is not espionage. So unless there's really something more, I haven't seen it, where he's really actively encouraging or actively helping, assisting. And I haven't seen that. The idea that he is culpable for publishing things that are told to him seems deeply problematic.
Isn't it
under First Amendment law?
Yeah, it's against First Amendment jurisprudence, which says even if something is illegally procured.
Yeah, exactly. It's the Pentagon Papers.
Yeah.
It's the Pentagon Papers, right? The problem with Snowden is that he voluntarily accepted a job with certain limitations. He accepted those limitations and he violated those limitations, and those are clearly violations of the law. And whether or not there's some sense justified in the grand scheme of things, I suppose is open, but I mean, it's clear to me at least that it's plausible. So yeah,
I think it's a violation of the law. That's why I like the pardon, because it is. I mean, he did violate the law. He's admitting guilt to doing that, but I think the overwhelming public interest in what he was exposing and the exposure of, as we now know from the Court of Appeals, unconstitutional activity, that says, okay, we're attenuated enough in time from this happening. Now we can go ahead and say, yeah, that was bad. And you could even say previous administration was doing the wrong things with the law. And now we know that, and he should be pardoned for it. He was guilty of doing some things, but we're going to go ahead and throw him a bone.
That's a valid political consideration. He was right in the end. Mm-hmm. But as a legal consideration, I'm less convinced, because normally when we think about law, we think about what you knew at the time.
Right.
and what was clear. So the fact that he's been validated after the fact, it's like, I don't know. It's like it's much more problematic. So if you think like he should be pardoned because he was proven right, I mean that's a political question, and Trump can do as he likes. But the problem for me as Assange is it's not clear to me he's really guilty of anything
I don't even know what
under
he's
U.S.
charged
law.
with. I haven't.
I did read the indictment. I thought it was crap.
Oh, okay. Yeah, I'll take your word for it. I just know like of Assange a little bit, and I'm largely just in support of journalists in general, but I
Right.
just don't know enough to have made a decision. But I'll take a look at it because I didn't even know what he was charged with.
Yeah, if the Washington Post can publish the Pentagon Papers, then how Assange can't publish what's told to him, I don't know.
Yeah, that's weird, and I definitely want to be able to publish stuff that's told to me. Kex7 Ghost says Second Amendment stream with Uncivil Law when talked about it because I saw your message earlier, and I think that'd be fun to set up. Joshua,
Would you mind giving me 30 seconds, please?
Absolutely.
Thank you.
All right. I will we'll wait for Uncivil Law to come back. I hope you guys are enjoying the show. After the show tonight, I'm going to go over on Twitch. We're going to watch Hatchet 2, the rated R version, which makes me sad. Because it's not the unrated version, but it is the rated R version. Hatchet 2. We'll watch that to start tonight. We'll watch something else after. Probably do Hatchet 3 over the weekend, and then the Legend of Lester Crowley, whatever. We'll watch that. That's Hatchet 4 basically. We'll watch that as well. Yeah, they're gonna be fun to do that. Hatchet 1 was so much more fun than I remembered, especially when the killing really starts. It was great. But that'll be tonight. Tomorrow I'm gonna try and get some Among Us time, but I'm gonna go on Yellow Flash's show tomorrow, 8:30 p.m. Central Time, as well. I'll be on Flash's channel for a live stream, so come check it out. He usually unlists them and then paywalls them, I think, for his Patreon. So if you want to see that show, and you're not subscribed to Flash on Patreon or something like that, you got to watch it live. So come do that. I don't know who else will be on, but that's going to be a fun time. Gelth, we're almost to your super chat actually. So I'm just waiting for Uncivil Law to come back, and then we'll get it. Yeah, I played Among Us the other day. That was fun. I want to play some Baldur's Gate 3. I think I saw Keck playing Baldur's Gate 3, and I heard like while one person is conversing with someone, if you've got a party, like you can go around and murder or pickpocket them while the other party member is talking to them and distracting them. That sounds fun. Welcome back. Welcome back.
No problem.
Okay, let's get through these. Final ones here. Joshua Vidrine says Second Amendment says I can defend myself by owning weapons. If I want to defend myself from the CCP, I need to be able to own something with a payload capable of wrecking an aircraft carrier. SCOTUS, please listen. Yes. Personal ICBMs is what I'm in favor of. I Hate Yankee says Joseph Story or Abel P. Upshar. I don't know. I don't even understand this question. Do you?
I recognize the name Story. I don't recognize the other one.
Okay. I have no idea. Mario Carter 13 says SCOTUS overrules Second Amendment by margin of 17-0. Squawk. Gelth Walker.
That's where we're going.
A question for you. Uncivil Law. For FUTAs, balls or no balls?
What's FUTA?
Okay. How do I explain this? It's an anime thing that involves I think a female character with male parts, so to speak. So then the question is, would they also have balls or would they have no balls?
I decline to express an opinion.
I'm fully on team balls. I'm like, if you're going to have it, have it. Chris French says, I almost got #MeToo'd. I'm glad you dodged that bullet, I guess. Amateur Ant says, I live in Michigan. The governor should be hung for treason. Bad Vibe says, careful saying that right around now. Bad Vibe says, my money is Biden gets Me Too'd or mentally unfit or both out of office. I don't think you can get Me Too'd out of office. Clinton locked that one down pretty well. Mario Carter 13 says, Trump stooped Wallace by saving Biden repeatedly. Or stopped Wallace from saving Biden repeatedly. Oh, okay. Rats. I like the way I read it the first time. Angry Baneling says, Nick, can you shill the like button? Thanks, fam. Yeah, go ahead, guys. Hit like on the thing. I never say that. I should. Phoenix Lord Asterman says, good stream tonight, guys. Uncivil Law. Do you have a recommendation video for someone new to your content?
Not in particular. You can just sort by most popular, really, and see what looks appealing to you, to be honest.
There you go. Death Trout says, wait. Sniffed her hair. Are we talking about Vic or Biden? Esme Illis Anime says, oh, cute. Nick, talk to Toy Bounty Hunters. He has those screenshots that you're looking for in abundance. Nick, your Miss Texas Chainsaw when? They don't have the original on Prime. If they did, I would watch it immediately. But they do have, I think, the remake. Maybe we'll watch that. Gerard Garvin says, 2-part harmony Lemons parody song with Cress when? Oh, God. At some point, we'll figure that out. SM Scorks 89 says, what is Uncivil Law's opinion on the Lucas Gerhardt case?
Don't know it.
Oh, you got to look at it. Brief summary. Kid is in college in the Upper Peninsula of Michigan, and he sends a Snapchat to several of his friends, and it's a picture of an AR-15 on top of like a tactical duffel bag, basically. And it says, bringing this up north to make the snowflakes melt. And by snowflakes, I mean snow. So he takes it up to school and checks it into the school armory, which is allowed. This is within campus policy, and is immediately arrested for terroristic threats. And he was then held without trial for 82 days in jail, and then denied bail, but released to house arrest, and has been on house arrest for now 11 months after his 82 days in jail. And he still has not had trial.
It seems to lack the specificity for a true threat, you know?
Oh, I should mention the person who reported the threat was not a recipient of his Snapchats. In fact, that person was blocked from receiving his Snapchats, saw it on another person's phone, and took a picture of it and reported it to police that way.
Okay.
It's a case I'm trying to get some publicity on because it seems like a kid is getting really hosed on what should be a free speech issue, but it's now a year old, and so there's not a lot of attention to it. But I think conservative commentators, especially First and Second Amendment people, should really be pointing out, like, this kid's 20 years old. He's lost over a year of his life. He's just had to stay home. He can't have a job. He can't go to school. He can't do anything. He's just stuck, you know? And,
yeah.
But yeah, it's a mess. Amateur Ant says, Julian Assange isn't even a U.S. citizen. How can the U.S. prosecute him for espionage? It's complete BS in my opinion. I mean, you can prosecute anybody who's under the jurisdiction of the United States for espionage.
There you go.
So his citizenship isn't an issue there. Whether or not he was under the jurisdiction of the U.S. when he was acting. And if arguendo, he's reaching in to get state secrets and procure them, he's entering the jurisdiction of the United States to do so, in either electronically or physically. But I think what you're saying and what seems to be the case is he probably wasn't doing that. People are just giving him stuff and he's reporting it, which is very, very different from espionage, unless he's soliciting the illegal procurement of the data. Big Red the Bard says, Medusa is being equated to Me Too because she was turned into a monster by Athena after being raped by Poseidon in her temple as a punishment. Correlation is that she was punished for something a man/god did. But why'd she chop the head off of Perseus then? Why not Poseidon? That's weird. Chris Tuckerson says, Von Dragon, you are a predator, and I want you to know it's true. Okay, there you go. That's oh shoot, one last one. Phoenix Lord Asterman says, Medusa was raped by Poseidon, cursed by Athena, and men came to her lair to harm her. Feminists say the statue gives her agency, despite the fact that if she won, Medusa would be doomed to a bitter, lonely existence as she killed all she looked upon. Yeah, well, mythology doesn't always translate perfectly.
There's a meta point there to be had, but I'm going to avoid it.
Yeah. All right. Well, that's all we've got for the chat. So, do you have any final thoughts for the stream? Otherwise, we can wrap up and get on with our evenings.
Oh, well, I'm happy to keep talking. If you want to wrap up, that's fine. So, but I have no particular thoughts. There are other topics, but I'm happy.
Yeah, I'm good for the evening. We're coming right up to 3 hours, so it's like perfect time length for the show.
Okay, in that case, I'll just give a general shout out for myself. If you liked my content, I'd appreciate you going over to my channel and subscribing to my stuff. I try to provide a thoughtful, thorough analysis and try to be as objective as possible. I'm a conservative legal thinker, so I tend to look at things just based on the law as it's written, not as I'd like it to be, and just try to look at process rather than outcome. So I try not to look at what's going to happen, and just try to look at what should occur based on the principles I believe in, and just try to apply them. So that's sort of my bias, as it were. And I do a lot of Supreme Court analysis, a lot of Court of Appeals analysis, lots of topical cases, and I invite you to come over to my channel and hope you enjoy my stuff and thoughtfulness, and I'm doing the best I can. So thank also to my host for inviting me. I appreciate it.
Oh, absolutely. It's my pleasure. I'd love to have you on again for sure. One thing we didn't talk about that you mentioned is how does YouTube Law, how do these channels, how do we collaborate? And
one of the things I've said before, and I've said this a couple times, and I'm happy to say it again, is I'm very interested in trying to build an academy online. Mm-hmm. I think the academy is any place people want to go to learn.
Right.
And surely that can be YouTube for every subject as surely as anywhere else. There's no reason that the academy has to be law schools. It can be anywhere, and it can be here. And so it's one of the reasons I do stuff with Viva Fry and Nate and Leonard. And one of the reasons I've been trying to reach out to you and trying to get something started, because I'm very interested in trying to figure out a way to grow this and grow interactions, and try to figure out a way to, build a new law school. So that's what I'm interested in.
Yeah, that's what Barnes was talking about. I had him on just the other day, and he was talking about lowercase d democratizing the access to legal education. Yeah. And it's not like you're gonna watch YouTube videos, learn a bunch of stuff, and go practice. Although maybe that's something that could be a future goal of reality. But for now, you're gonna go into the legal system knowing a little bit more, and just having some perspective on how it works. And that's a thing that is universally beneficial for people, I think. Because I think that's criminally under taught in high schools, is how you interact with the law and what it actually looks like. I took a law class in high school. I basically failed it. I think I got a D in the end. But it was completely pointless. Like, there was nothing I learned in that class translated to real world law in any way. And so I don't even know why we had it. It was a mess. We watched 12 Angry Men, which was fun, and Anatomy of a Murder, which was great, but that didn't help anybody deal with the law. I guess unless we were black in the 20s or whatever, then it would be helpful. But anyway, well, I've really enjoyed having
the jury in 12 Angry Men was wrong.
I've really enjoyed having you on. I'd love to have you on again. And if you ever wanted me on your show, I'd love to come on as well. I like interacting and chatting with people, and getting to nerd out on legal topics is always fun. So I respect what you're doing. I hope your channel keeps growing. And you seem like a really, really nice and just decent guy in general, which is more than I can say for like me. So, but
you've been decent to me.
Well, that's because you're decent back. But no, so I definitely want to have you on in the future, and specifically on Second Amendment stuff. Now that I know that that's one of your passion points, I would love to really like kind of needle into that. And I've been looking for some people to flush out a good Second Amendment stream. Also, people have been yelling.
I've also had the virtue of meeting Alan Gura a couple times, and I've met Heller a couple times.
Oh,
I
nice.
met McDonald before he died. McDonald was always a very quiet guy. He seemed to not like the limelight. But yeah, I've met them all.
Very cool.
So.
Well, we'll have to we'll set that up. 2 more chats came in, and then we'll wrap up the show. Mario Carter 13 says Medusa made all the men rock hard. And CJ says, in high school, Nick got a D in the end. I blame Drexel. Oh, come on.
Nice.
Come
Very
on.
Good.
All right. Well, if
I'm picking up what you're laying down.
If you'll hang out for just a second, okay. I always like to say goodbye to my guests in private. So to the stream, thank you all for joining us tonight, and go check out Uncivil Law's channel on YouTube, and go check him out on Twitter as well. And then other than that, we'll see you later this weekend, and come over to Twitch in just a little bit. Have a good night, guys. Peace.